that building would only be on Thursdays. That is on the asking of some of the advocates who found it very difficult to go to that building twice a week. All right, yes.
Adjournment request, if any, from item number 1 to 5.
May I please, your lordship, with the consent of the other side, I beg to mention item number 2, lordship. We seek one more week to file our rejoinder, lordship.
All right. Give the date.
1/6
Much obliged.
for June. From item number 6 to 18.
May it please, your lordship, with the consent of the other side, I beg to mention item number 13, lordship. My senior is out of session, lordship.
6 to 8 first.
6 to 8.
Your turn will come.
May I please, your lordship?
Yes.
With the consent of the other side, I beg to mention item number 6 to 8, lordship.
15/6.
Adjournment slip circulated.
Yes.
May it please, your lordship. I beg to mention item number 13, lordship, with the consent of other side, lordship. My senior is out of session.
17/6.
Please, my lords, with the consent of the other side, I beg to mention item 11. I'm
11?
I am appearing on behalf of Mr. PZ Football, Lanet SCGU.
This is NCT derecognition of a college. Now, that's a serious matter. How many times would we adjourn?
My lord, on instruction of my senior, my lord, the respondent number 10 was filed on every decade. So my Lanet senior needs 2 weeks time to see, to go through the
As
contents.
prayed for on behalf of respondent number 10 and agreed to by.
I am for the claim people.
Respondent agreed to by the council for the 10.
I'm pleading on behalf
Agreed
of
to by the
council
council
for
for the
1 to 4 fiction.
petition. I kept on. Where is
Item
that?
11.
The matter is adjourned to. Consultate.
He is on behalf of 1 to 4, madam.
I'm on behalf of 1 to 4.
Acha, for response number 1 to 4. But we will not be interested in granting adjournment in this. Any further. Now be ready of that. This can't linger on, no? And what's happening?
Well, in fact, the orders have been passed in our favor, the very foundation on which the.
You're for that institute?
Yes.
No.
No.
If you're relying on a Delhi judgment, Delhi High Court judgment order, that is.
After the signing of this
interim
PRN.
order.
Hello.
And that order we don't agree to.
Well, these are different
There is
contents.
a
different order now, where a series has been
We'll see. We'll see. For the 6th July.
15 July.
Lordship, I would like to mention item number 14, Lordship. Yesterday we have.
You have circulated.
Lordship.
Yes.
Much applied.
16 July. From item number 19 to 23, adjournment request.
May I please, your lordship, with the consent of the other side, I beg to mention item number 21. Lordship.
21.
Lordship, Mr. KL has some personal directive.
On the ground of unavailability of Mr. C.K.L., learned senior advocate for the petition, the matter is adjourned. Have you informed the other side?
Lordship.
The matter is adjourned to. Again, July.
21/7.
Much obliged, Lordship.
May it please to your lordship, I beg to mention item number 23. We have submitted
23.
We have submitted a criminal.
circulated.
What is this matter about?
Regarding termination of this.
You are unnecessarily having it lingered. We have heard it. Why do you want it then?
Lordship, senior counsel Mr. PJ has some difficulty today.
As prayed for on behalf of the petitioner. Re-notify next week. Look. Next week. Next week.
5/5.
Matters
But
which
if
are keeping for a
possible,
long time. This is the
14
2024
or
matter.
19.
2026 matter, we understand, we give you time. Then 25 also we can, but 24, 23, these matters, we don't want to pass orders for adjournment. Anyway, next week, be ready.
Lordship, if possible, 14 or 15, 19th of May.
Not on 14, any day.
19.
19.
Oblige. Highly oblige.
Any other request?
My pleasure, Lordship. I was praying for a listing of a matter, Your Lordship. We have filed it on 24th of April, Lordship. The judgment is of 31st of March. Lordship, whereby my license has been cancelled by the
License for what?
license for liquor shop, Lordship. It's a
Liquor shop.
Yes, Lordship. But that was not even the prayer in the petition, Your Lordship. And my humble submission is that the petitioner has no locus because to file the petition because he was not even valid to participate in the tender. Lordship, if I may request, can it tomorrow or
No, tomorrow is not.
day after tomorrow?
Next week.
Lordship, day after tomorrow, Lordship, because the department is trying to close my shop, Your Lordship. Lordship, may hear it, Lordship, then I have no issues. Friday is holiday, I believe, Your Lordship. Friday is holiday. Huh?
This Friday holiday.
Otherwise, I have to pray for Friday.
Let it be listed on 30th.
Okay,
Thursday, Lordship.
Thursday.
Much obliged, Lordship. Much obliged.
All right.
Daily list for admission, item 1.
Please, your lordship. My lord, applicant wants to approve this case, madam. They already,
Because of the judgment rendered by us in some other matter.
no, my lord, they already got the relief.
All
Yeah.
right, so on the date fixed, you were appointed.
Yes, your lordship.
You are Mr. Datta.
M. Islam.
Mr. M. Islam, learned advocate for the appellant, seeks permission to withdraw this application as his grievance has already been, withdraw this appeal as his grievance has already been prepared. Dismissed as withdrawn.
Early obliged, your lordship.
I also. I also.
Item 3.
My pleasure, Lordship.
Haven't we decided about the constitutionality of 31G?
Your Lordship has decided on the issue of man and woman.
No, we have decided it on the issue of it being absolutely valid justification.
Yes, Your Lordship. Once Your Lordship has decided,
The better option for you is to approach the superior.
Your Lordship, may I just submit one aspect? In the meantime, the Supreme Court is hearing a similar issue where the age is 61, husband, and the wife is 56. There also, the Supreme Court, while keeping the matter alive,
But how can we entertain any argument when we ourselves have decided?
no, Your Lordship, what has Your Lordship decided is,
One thing, maximum relief that you can get from us today is we can adjourn the matter for you to see what happens in Supreme Court.
Your Lordship, that is right. One way. What I'm only praying, Your Lordship. Here is a case, Your Lordship, in the other judgment also, Your Lordship has sympathized with the parents.
We have
I need some sympathy, only in the sense that let
parents, but the couple.
couple,
Couple.
right? Your Lordship, what I'm seeking is that let me undertake a preliminary test only, whether I am able to go for IVF or
No,
not. Because the Supreme
It's a
Court has also,
It's a complete embargo, Mr. Counsel.
no, Your Lordship, in commissioning couple, there is no age been provided.
No.
Yes, Your Lordship, if Your Lordship sees the act,
We will not be able to give you that relief, Mr. Senapati. We will not be able to give you that relief. No matter how much we may want to give you that relief.
Your Lordship,
Because the age and the capacity and the procreativity or your virility, these are all issues which are very, very personal to you. But then we cannot question that once we have upheld the legislation. We
yes,
have
Your
said that it is constitutionally valid.
constitutional valid in respect of the prescription of age in respect of man and woman.
Yeah.
Your Lordship, just 1 minute. I'll just take one. I'll give an analogy. A unmarried woman below the age of 50 is eligible to undertake the IVF
We have
treatment.
found that.
Right.
In fact, we have taken note of this argument in another matter which was authored by me. The other has been authored by my brother.
Two cases, Lord. Two petitions. WPC 7113 of 25 and lordship, 2344 of
We have
2024.
taken note of that argument. We have said that it becomes discriminatory that way. We have taken note. That's not a new argument Mr. Senapati, that you are advancing. We have taken note of that. But these are on the basis of medical inputs.
But your
We
lordship,
can't substitute our wisdom or perhaps your
absolutely.
arguments.
Your lordship, only just for my satisfaction, I'm just saying. IVF came about in India from 1978. Till 2021, there was no upper age prescribed. Now, what my understanding is, in respect of a woman, egg can be donated, sperm can be donated. With regard to the ovary, or not uterus, according to doctor and in terms of medical science now, a uterus is an evergreen thing. It can, by all treatment, be kept evergreen. And even after attaining the age of menopause, even after attaining 61, 70, you can still bear a child. Maybe the egg may not be good, the sperm may not be good, but the uterus can be kept alive.
I'll tell you what. The maximum concern shown by the medical world, which led to the formation of this statute, was higher chances of children born with Down syndrome, Tourette syndrome.
But if the statistics,
Mr. Senapati, we will not be able to get beyond that.
your lordship, in that case, I'll
You can
still,
seek an adjournment or we can decide it now.
no, I'll seek an adjournment because I'll like to keep my hope alive. If the Supreme Court gives something on the age of 61 and 56, definitely, because my client,
That be implied overruling of our judgment, and in that case, we will go by what you say.
then I'll keep my hope alive. Your lordship, I'll seek an adjournment.
Is prayed for on behalf of the petitioner, re-notify sometimes in August.
Not August, 3 Item 4.
May I please go?
Distinction will go. Yes,
May I please, my lord? This is an appeal prepared by the CRPA and its Principal Union of India. Now, my lord, in this particular appeal, we are challenging the judgmental order dated 28/5/2024 passed by the learned single judge. Now, my lord, before I directly come to the order, I would like to give a brief account of this case. My lord.
yes.
In this case, what has happened, my lord, a departmental proceeding was initiated against the writ petitioner in the year 2009. Thereafter, it ended on 31st/12/2013.
Ended on 31st,
12/2013.
2030.
At conclusion, my lord, the petitioner was found guilty of all the article of charges that has been leveled against him. Accordingly, he was given punishment of reduction of pay by 2 stages for 2 years. Thereafter, my lord, that particular punishment come with a rider that further direction that he will earn increment of pay during the period of such reduction, and on expiry of such period, the reduction will not have the effect of postponing future increment. This is the rider, along with the punishment that has been imposed. Thereafter, my lord, in the meantime, what has happened, DPC has been constituted. And that DPC has been constituted on
DPC for vacancies of which year?
Vacancy of 2015 and 16, right?
2015, 2016.
16. And DPC had been held on 22/6/2015, when his currency of punishment was continuing. Thereafter, my lord, after appraising
No, 22/6/2000. DPC was held on
22/06/2015
6.
for filling up the vacancy
that means promotional revenue.
So the promotion to the respondent was given from 1st of January 2026, when the currency of the sentence was
Yes,
judgment was
continuing.
over. When it was over, he was given.
Yes, my lord.
And what has the learned single judge held?
The learned single judge is of the view that, my lord, that once the punishment of reduction of pay by 2 stages for 2 years has been granted, if his promotion has been effect to a future date, it amounts to giving the second punishment. That impliedly a kind of double
Did
jeopardy.
you not show that paragraph in Union of
No,
India versus
let me come, my
Antiraman?
lord. And another observation that has been made, I'm coming to the next observation, my lord, now. That my argument before the learned single judge that the action taken by the competent
Correct.
authority.
We are absolutely with your view. Yes.
In fact, the issue was not regarding losing of seniority. Whether the punishment, lot you will find at page 200.
You can't be promoted as a matter of law, as a matter of disciplinary jurisprudence. You can't be given promotion notwithstanding the DPC clearance. During the currency of the punishment, it has to go.
Right.
And then when the DPC was made, perhaps this was also said that you would be promoted. Eligibility and entitlement are two different things.
Yes.
So therefore, we do not find any justification for the learned single judge to have decided likewise.
In fact, my lord, the issue was, my lord, issue advanced by the petitioner was, my lord, whether in the effect of this punishment, my lord, page 200, my lord, losing of seniority is the issue. Whether he will lose his
That
seniority.
comes later. First thing is that DPC clears your name.
Lordship.
You are given promotion, notwithstanding the fact. In fact, it was a seat cover procedure. This time it was a seat cover. It was not a seat
It
cover.
was seat cover, seat cover.
My lord, it was in seat.
It was a seat
It
cover.
was in seat cover.
So you got it. Now it would have opened only after the currency expired.
Lord. Page 236, my lord, paragraph 18.
What?
Of the thinking judgment.
That's
That's relating to seniority.
principle wise, that's erroneous.
Seniority was the issue, my lord, in fact. But whether the person will lose his original seniority because of the fact of imposition of penalty.
And then you come up and say that this sentence was bad.
Lord.
You lost out on
In fact,
financial terms.
The petitioner relied
That's
upon the
not the consideration.
OM dated at page 155.
Unless it specifically says that the promotion shall be granted notwithstanding the currency of the punishment.
Page 155.
No inferential thought here. I mean, I don't think the issue is carried question. It admits of no further explanation.
In fact, he prayed for a restoration of his seniority, original seniority.
How can that happen? You were not born in that cadre. How can that happen? What is the purpose? Does it not, what the elected single judge has done, has it not neutralized the punishment? Through back door. Not through back door, through front door.
Page 157, but the relevant portion of the office memorandum, where the period of reduction is specified in the 157, my lord.
Yes.
Second paragraph, my lord, Roman
1 second.
157, 150. That is the part of the office memorandum, my lord.
Yes.
Where the period of reduction is specified, whether on
No,
the
read clause 5 from the beginning.
lordship. The period of reduction, unless
Or you
clear
do one
instruction
thing.
is there,
One
reduction
thing. This
should
has
be
been relied upon by the learned single judge.
lordship.
Let's see what the office memorandum says. Let us also not go wrong. The understanding is directed to invite.
It is in respect of restoration of the original seniority. Second paragraph, where the period of reduction is specified, whether on the expiry of the period, the government
You're
servant
reading
is to
from
be
which page?
157 small Roman 2.
Small?
Roman 2. At the top. Where the period of reduction is specified, whether on expiry of the period, the government servant is to be promoted automatically to the post from which he was reduced. My lord.
So refused.
Refused, my lord. And the last B, my lord. If the period of reduction does not operate to postpone future increments, in my case also same thing, my lord. The government servant on re-promotion will regain his seniority. That was in fact the issue. He will not lose his seniority. Once that will amount to a double jeopardy. He will lose his seniority.
Mr. Dekar,
Yes, my lord.
now has this 1990, this is 1962, sir.
1962, my lord.
1960.
Later circulars, they make any change, but this is not in accordance with law. Where are the later circulars?
Latest circular is at page 153, 2007.
Later circulars are at which page?
53, my lord. 14th May 2007.
What does it say?
Same thing, my lord.
Where is it?
First paragraph, last line, my lord. Without further restoration of the grade or post or service.
Read the entire paragraph.
Lordship.
Paragraph 4.
Yes, my lord.
Page 153.
153, my lord. The
Paragraph
minor
4.
penalty and major penalty in Rule 11 of CC Rule 1961 have been graded in order to severity to the awarded to the charged officers, charged government servant in proportion of gravity of the misconduct negligence that has been raised in charge. While the minor penalty of compulsory retirement removal, major penalty of compulsory retirement removal from service, and the minor penalties of major penalties of removal and dismissal from service has been introduced in clause 7, 8, 9 of the said rule. The penalty of reduction to the lower time scale of pay for grade post has been incorporated herein. This clause also provides while imposing penalty, the disciplinary authority and appellate authority is also required to indicate the penalty order whether or not the individual charged officer should be eligible for restoration of his grade post service from which he was reduced and his seniority and pay. So once the punishment is minor punishment,
Read the other paragraph. 5.
Lordship, attention of the contention is also invited to the government OM dated 10/10/62 that I read, my lord. That is at page 155. Lower time scale should invariably specify the period of reduction unless it is clear intention that the reduction should be permanent or an indefinite period. So it will have to, the penalty or the,
If you for putting any gloss over any circular, the circular has to be read in its entirety. Please read it
Lordship,
or allow us to read if you don't want to read it
Lordship,
in its
this
entirety.
instruction
Now
also,
start from the beginning. Attention is drawn.
attention is, in this connection is also invited to the government of India's OM number so and so dated 10/10/1962 that I just read, my lord. And number so and so dated 7/2/1964, copies enclosed, which stipulates that an order imposing penalty of reduction to a lower service or grade post or to a lower time scale should invariably specify the period of reduction unless the clear intention is that the reduction should be permanent or for indefinite period. This instruction also indicated the manner in which the order should be framed when the reduction is for a specific period or indefinite period. In case the intention of the competent authority is.
But where does it say that it will have impact on the DPC clearance for promotion? Where does it say so? It says that it has to be specified, and I think the sentence, the punishment imposed upon you, the penalty is very, very specific. It says reduction to 2 stages for 2 years
2 years.
with no postponing effect, and you'd be earning the increment during those period also. That's all. It doesn't say that it will be for permanent, for all time that you serve. Correct. So where is the latitude? Where is the passage for you to claim by virtue of this circular or 1962 circular that this promotion to you would be given notwithstanding the currency of the punishment?
That was not the, not
See, the purpose of this was, you can see this from paragraph 4.
lordship.
Because a distinction was to be made between minor and major penalties. This was for mitigating the severity. And therefore, in all fitness of things, the OM says that when punishment is imposed, which is not major, like compulsory retirement, dismissal, it should be specified. The period, the duration should be specified. That's all. So this OM only clarifies that it should not be left open-ended.
Open, yes.
This is what I read, unless you tell us and make us think otherwise. This is what we read.
Right.
Now, therefore, whether promotion, otherwise, what is the purpose of that law which says that you can't be promoted during that period? Once that period is over, you are promoted, but that promotion would be not from the retrospective date.
Right.
Otherwise, it will be mitigating the entire disciplinary jurisprudence.
Right.
ये ऐसा हमारा मानना है, but I think you need to argue on this. The
These-
single judges relied solely on the circular of 1962.
And in fact, my lord, this, Lalit Singh has also relied upon two honorable apex court judgment.
इसमें कहाँ seniority के बारे में था? It says,
Please, ma'am.
paragraph 4, penalty order, whether or not the individual charged government servant would be eligible for restoration of the grade post of service. Now, grade and post of service here does not refer to a situation where you would get promoted. Now, this doesn't talk about seniority in case you lose out on promotion from a particular date and your contemporaries, your juniors get promoted earlier. Now, if you try and link it, then perhaps the anomaly would arise.
And my lord, this is a case of reduction of.
Let him argue. You are,
I have
court
my
is with
apology.
you, therefore the maximum time should be given to Mr. Sharma.
But in fact, my
No,
lord,
we don't want to go wrong that way.
lordship.
Correct. You are talking about seniority. That's an ingenious argument.
Yeah.
We understand that.
In fact, my
The
lord,
distinction you have been able to carve out, but then we don't see that latitude, that passage in the circulars we don't see. If you talk about restoration of the grade/post or service, then it is pre-sentence, pre-punishment. You get back to that post and you also get promoted. But you can't relate it to the grade to which your juniors have been promoted in the meanwhile.
the contention before the.
Otherwise, nobody on this earth, no civil servant would ever contest these minor penalties.
Lord,
It has to have that deleterious effect on your service, notwithstanding the fact that it specifies, there is a caveat, it says that there shall be no postponing effect after 2 years, and you shall be earning your increment during the currency of that sentence also, of the punishment. I'm sorry, I'm using the word sentence, punishment also. So therefore, this law, how do we neutralize the law which has evolved over a period of time? Circular or no circular? This is the law. I think from 1994, Janki Raman is 1994 or 1991?
1994.
Janki Raman mangai.
in fact, the Lalit Singh just relied upon two judgments.
No. We would like to have 1991 for SCC 109. And till 2007, which is off-quoted, Union of India versus A.N. Mohanan. Up check up kariye, this is something which requires an argument. This is for the first time that the matter is being heard.
Lord,
You want to prepare further on Janki Raman?
no, I'll take care. I'll satisfy your lordship. In fact, there are two judgments.
Up
Which
till
is
now, we are with the Union of India
lordship, Lord.
for our own understanding.
These are the two judgments, my lord.
And you have a tainted record, Mr. Sharma. You have a very, very tainted record.
Yes.
You're not a person with a neat record, but that doesn't bother us.
Lord,
We have been called upon to decide something
Lord,
else.
Lord. last page Lordship will find.
No, just a minute. Janki Ramani with us. Clear it. Now, paragraph. Okay. If employee is listed with any penalty in discipline, seat cover shall not be acted upon and in case of that's DPC. Important happening that DPC also put out a Government of India training, dated so and so, circular dated so. Now, no one offense. Then second one, non-promotion of an employee till date on which he was held guilty and penalized. It would not amount to double penalty. It doesn't fall within the mischief of Article 20 sub clause 2. And then employee has a right to be considered for promotion and not a right to promote. Past record including penalty or penalties awarded to employee can be taken into account while considering his promotion. Now let's see the details. Justice Savan, this judgment is kind of weight maker for service. I think these circulars also have been taken note of.
In fact, my lord, I have two judgments, one of 1996 and another of 2018.
We'll get back. And could they have helped the DPC so far as you are concerned under seat cover also? But this was not under investigation, you had been punished. Got it, punished. So that would have come in the next DPC for the vacancies of 16, 17.
That is why.
If you go on that, perhaps even this DPC is bad, you don't even get promoted from 2016.
Is
Mr. Sharma,
37, my lord.
that also.
Lawsuit. That is page 2000, last page of the appeal, my lord. My seniority has been restored without hampering the promotion of the page paragraph 21.
Your seniority has been restored.
Seniority, only seniority has been restored, not the punishment, not antedating the punishment. My original seniority has been restored.
Then what is your grievance?
No, it is, they filed,
If the seniority has been restored, what is the grievance?
I don't have any.
He has not-
My lord, the grievance is there.
Paragraph 21, my lord.
Then why did you go before the legislature?
It is filed by the Indian Embassy.
No. Before single judge.
Single judge ordered, my lord. Please,
Why, what was your grievance before the learned single judge?
restoration of
Seniority is restored.
senior restoration. In fact, initially it was not restored. Initially, it was the date of promotion. My seniority has been fixed.
No,
Then I,
can't happen, no. You get promoted from a later date. How can it happen?
but original seniority has been restored.
How can that be?
In the other grade, because the
Other grade is all right. That is by virtue of the circular of 1962.
yes, that has been restored. Please,
Mr. Sharma, don't conflate issues like this.
237.
It will go against you only if you try and conflict. See, that is what the circular mandates.
Lordship.
That after that period is over, in fact, your seniority otherwise also was not disturbed because it was only a reduction in the base days.
Lordship.
So your seniority remained your related, brought back to your own seniority. But so far as promotion is concerned, you get promoted only from the date
Lordship. That
when the currency of the punishment was over.
over.
So that way, any person, even if junior to you was promoted earlier than you can't be senior to him.
Right.
So therefore, this is what the learned single judge has done.
The operative parties, my lord, this writ petition is allowed as indicated above, and the respondents are directed to grant the benefit of seniority. Sorry. With effect from the date he was recommended.
Now, taking just
2018 judgment. No, this is a 2018 judgment.
we would also like to see Murugation. Tamil Nadu versus state of state of Tamil Nadu versus Murugation 1995, supplementary 3, SCC 273.
Yes, my lord. That judgment also I have. My lord, issue in this particular petition was from which date this seniority should be reckoned. Whether it should be 1/1/2016 or 22/6/2015. This was the issue.
Who is understanding it differently? That is the issue why we need to repeat it.
Right.
Who is not understanding the issue? Mr. Sharma knows it. And at least you must trust the bench. We also understand what it is. Repetition is not required. It is not needed.
I'm sorry.
No, don't be sorry. I mean, this is the way we respond to the argument.
Yes, my lord. Number one judgment I'm relying 2017 volume 6 SCC 394. Might not may directly come to page 10. Page 10. my lord.
Which paragraph?
My lord, this is a continuation of the paragraph number 18. But this particular judgment has referred to another judgment 91/4/2009. This is B.K. Janagirama. Here, my lord, this is the observation.
So this is okay.
And relevant portion is in bold letter. by the way. When an employee is held guilty and penalized and is therefore not promoted at least till the date on which he is penalized, he cannot be said to have been subjected to a further penalty on that account. A denial of promotion in such circumstances is not a penalty, but a necessary consequence of his misconduct.
This is what
In fact,
Janakiraman is. This is what Janakiraman. This is quotation from Jan. Therefore, we said Janakiraman is the, it still holds the thing, it shall hold the thing for times to come. No, sir, this, the judgment giving benefit to you has to be overturned. Take it. The Union of India, Dashapalan, has questioned the judgment dated 28/5/2024, passed by a learned single judge of this court in WPC number 8036 of 2017, whereby it has been directed that the respondent herein be given promotion and consequent benefit of seniority with effect from the date he was recommended by the DBs, that is 22/6/2015, instead of 1/1/2016, which is the date on which the currency of the punishment imposed against the respondent in a departmental proceedings ended. Ended. The respondent was subjected to a departmental proceeding. And on the basis of recommendation of the inquiry, and on the basis of the recommendation of the inquiry officer, he was saddled with the penalty of stoppage of 2 increments for a period of 2 years, with the caveat that he shall be given the increments which he would earn normally within those 2 periods. And such reduction will not have any postponing effect on the future financial benefits to the respondent. This penalty was imposed on 31/12/2015. 31/12/2013. During the currency of the aforementioned punishment imposed upon the respondent, a DPC was held in which the case of the respondent was considered and he was found fit. The DPC, the recommendation of the DPC, however, indicated that the respondent shall be promoted from the date when the currency of the punishment imposed upon him would expire. Consequently, the respondent was promoted, but from 1/1/2016 and not from 22/6/2015, the date of recommendation. This late promotion to the respondent had obviously disturbed his seniority. And therefore he challenged the decision of the employer in granting him promotion from 1/1/2016 before a bench of this court, as has already been referred to earlier. The learned single judge delved into a number of facts appearing in the case of the respondent and found that he had been considered by the DPC in the past on several occasions with respect to vacancies of those respective years. In all such DPCs, the case of the respondent was considered and put in sealed cover. On 18/9/2014, the respondent was again considered for promotion and was found unfit. However, for the vacancies arising in the year 2015 and 16, another DPC was convened on 22/6/2015, wherein also the consideration with respect to the respondent was made under sealed cover. Sealed cover for the reason of the respondent having been put to a punishment of reduction of pay for 2 stages for 2 years, and the currency of such punishment still subsisting. However, the DPC on 22/6/2015 declared the respondent to be fit for promotion for the vacancy of the year 2015-16. But as noted above, clearly recommended that the respondent shall be given the benefit of promotion after the currency of the punishment. The currency of the punishment ended on 31/12/2015, and consequently, the respondent was promoted to the higher post, promoted to the rank of commandant with effect from 1/1/2016. The learned single judge, relying on a Government of India, Ministry of Home Affairs Office Memorandum dated 10th of October 1962, where it was stipulated that where reduction is for a specified period and is not to operate for the purposes of postponing future increment, seniority of the government servant may, unless the terms of the order of punishment provide otherwise, be fixed in the higher service grade or post or the higher time scale at what it would have been but for his reduction. Reading this as a rider, the learned single judge opined that in case of minor punishment, with clear stipulation that the punishment will not have any postponing effect on future financial benefits, the respondent was required to be restored his seniority. With utmost respect at our command, this reading of the circular was misdirected. All that the circular recommended was that in cases of minor punishment, with a specific stipulation of its currency for limited period, the delinquent / employee shall be reverted back to the position to which he was prior to the punishment. This could not have been related to a future promotion for which DPC was held separately for a vacancy arising in the year when the DPC was concluded. The law with respect to disciplinary jurisprudence is well settled. Promotion can only be given after the expiry of the penalty and not from the date of the DPC recommendation. The assumption that once recommended by the DPC, promotion must relate back to the date is uncalled for. A subsisting penalty creates a legal bar, and granting retrospective promotion would neutralize the penalty indirectly and would severely undermine the disciplinary jurisprudence. Refer to K.V. Janakiraman, a Union of India and others versus K.V. Janakiraman and others, 1991, 4 SCC 109. And Muhammad Faisal AA versus D. Sali and others, 2017 0 Supreme (SC 971). In both the judgments, next pattern, in both the judgments referred to above, it has been clarified that on principle, an officer cannot be rewarded by promotion as a matter of course, even if penalties otherwise, even if penalties other than that of reduction in rank. An employee has no right to promotion, but only a right to be considered for promotion. To qualify for promotion, the least that is expected of an employee is to have an unblemished record, which is the minimum expectation from a government servant. An employee found guilty of a misconduct cannot be placed on par with other employees, and his case has to be treated differently. In this context, it was held by the Supreme Court in the aforementioned two judgments that there will be no discrimination on such an employee when in the matter of promotion, he is treated differently. It was further elaborated that if an employee is held guilty and penalized and is therefore not promoted till the date on which he remains penalized, he cannot even be subjected, he cannot be said to have been subjected to a further penalty on that account. A denial of promotion in such circumstances is not a penalty, but a necessary consequence of his conduct. Necessary consequence of his conduct. None of the circulars relied upon by the learned single judge give any passage to an employee to claim promotion from a date when he was recommended by DPC during the currency of a punishment imposed upon him in a department. Seen thus, we do not approve. We do not approve of the reasoning given by the learned single judge in the judgment in blue. And perforce, we have to. And perforce, we require to upturn this thing. The order accordingly. The judgment impugned in the present appeal is set aside. The respondent shall be promoted from the promotion to the respondent from 1/1/2016 is restored. The appeal stands allowed to the extent indicated.
Item number 5.
We have made that distinction, Mr. Sharma. We have made that distinction, Mr. Sharma, for the reason that we don't equate that bringing you back to the same seniority with the promoted, with the seniority which you get out of promotion. That's a very valid distinction which we have thought of.
All right.
In this matter, my lord, please. This matter,
Mr. Indranil, you lose your job that way.
this is what happens if you are so qualified as to be a PhD from IIT.
No. We are not concerned with your qualification now. Now you committed a mistake in overstaying the lien. Correct. But then, did we stay that judgment?
That is what the FRSR says, and that provision has been interpreted by the Supreme Court in 2-3 cases. That even with the consent of the employee, the lien cannot be terminated. There is a specific provision in FR 12A,
Just a minute.
and that is exactly what.
One second. Mr. Gogoi,
Lawsuit.
termination of lien we will say, but he must retain his service, no?
Absolutely.
You terminate his lien, he has been removed from that position in the government. And then you don't allow him to join this college, Gauhati Engineering College. That is, triple jeopardy.
That part also I will explain.
Lien when he can no back wages, nothing.
That
Let him go and join. At least let him retain his
was
service.
it's a
So what?
tenure.
You can't be- you
It's a tenure post
You
Lawsuit.
can't be so heartless, I must say.
That I'm not saying that it's a tenure post Lawsuit for a 5-year period of time.
We have followed that, Mr. Gogoi. Don't get back to the old argument. He has overstayed, it has been terminated. Correct. We justify your stand. But let him go back. Because there was a stay order in the meanwhile and therefore he could not join. Now allow him to join into his original Gauhati Engineering College. You can't make him lose his job like this.
Otherwise, hold that.
You selected him, no? You
No,
selected him for
no,
Gauhati.
No lawsuit. It's a outside Kedar post Lawsuit.
Outside?
Outside Kedar. It's a he's a
This way, take a call. Otherwise, we'll say that it will be very harsh.
Getting back to his post at
In
Jorhat,
that
forget
case-
about all Lian and all that.
In that case, we ratify the judgment of the London civil judge, notwithstanding our having stayed the operation of the judgment, but he must retain his service. No back wages, nothing.
That part Lawsuit, I'm agree Lawsuit. Otherwise,
Take instructions and get back to us. Otherwise, see, many a times you don't realize.
that part, otherwise Lawsuit, the whole case is the petitioner was there. He's a permanently observed in that particular director.
No, that is not a fact. Question is, if there is a permanent absorption, he would never come out.
That's because.
How do you say he has been permanently absorbed?
My lord, may kindly pause for a moment the appointment letter also.
It was for 1 year,
No, appointment is for 5 years. It's
5 year, but he has to come back.
No.
appointment.
Had I been permanent, how could the Gauhati University have terminated me?
Look at this, Mr. Gogoi.
Lawsuit.
Try and understand facts simplistically. Don't just get back to, what you have to proceed with. He also stayed on your asking,
Lawsuit.
stayed the operation of the judgment.
Lawsuit.
But today we are of the view, look at this. He was an associate professor in geology in Gauhati
Lawsuit.
Engineering
Lawsuit.
College.
Lawsuit.
Correct? This
Lawsuit.
fact is not disputed.
There's no dispute.
Now,
No dispute.
in 2015, he was appointed as director of the College Development Council at Gauhati University.
Lawsuit.
Fixed term of 1 year.
No lawsuit.
Fine.
So my
Fixed term of 5 years.
lawsuit may kindly
No.
peruse page 71.
You
Sorry,
tell us
sorry,
the
sorry,
facts.
sorry.
Why do you want
No,
to?
lawsuit.
He was appointed as director of College Development Council at Gauhati University for a fixed term of what period?
5 years lawsuit.
5 years.
5 years.
1 year, but
No lawsuit. 5 years.
what is that page 74?
Yes. Suppose in 1 year dekha tha.
Page 74, we have given the lien to him lawsuit.
That is
74
what
is
I'm
the lien.
saying.
74, we have given lien to him for 1 year period lawsuit.
For 1.
For 1 year.
Only for 1 year.
Only for 1 year lawsuit.
University gave him 5 years.
Wait,
but
wait,
given lien to one.
Okay.
Am I
No lawsuit, lawsuit.
Just a minute. Page 70, page.
Page 71 is the appointment letter lawsuit. Page 71 is the appointment letter lawsuit.
Page 71 is the appointment letter.
Appointment letter.
Appointment as
Name of the post
Director College Development Council.
and nature of the post is permanent lawsuit. Column 2 lawsuit, serial number 2 lawsuit. And serial number 9 also lawsuit. Retirement benefit as per the provisions of the ZU pension rules lawsuit.
Right. No. So he got appointed and lien was retained only for a year.
Only for 1
So
year.
that if he doesn't like that posting, he can come
We
back.
can come back lawsuit.
No.
And
Where is that order of lien?
lien,
Now you are making some sense.
page 74 lawsuit.
Page 74.
Page 74. Page 74.
Read. The governor of Assam, read it.
The governor of Assam is pleased to grant lien to Dr. So-and-so Losi, Associate Professor of the Zoology Department of Gauhati Engineering College, Gauhati, on being appointed to the post of Director of College Development Council, Gauhati University, Gauhati, for a period of 1 year with effect from the date of handing of her charge in the present post in terms of the Finance Department of so-and-so Losi, and on the condition that he must return to the parent department on completion of the admissible lien period.
Correct.
Or
So thereafter, and how do you say that it was for 5 years? This post is permanent?
lordship, advertisement was issued, my lord, may kindly peruse page 70, lordship. Page 70 was advertisement issued by the Gauhati University, lordship. It says that, lordship, director of college development of one post initially for a period of 5 years, lordship.
Advertisement.
By page 70, lordship. Page 70, CL number 3, lordship. Page 70, CL number 3, lordship. Director of College Development Council, 1 year post initially for a period of 6 years, lordship. 5 years, lordship.
Then
5 years, lordship. Then, lordship, appointment letter is page 71, lordship. Nature of the post, lordship, CL number
nature of post is permanent.
permanent.
His appointment was not permanent. Because this is only for 5 years. It was by
5 years.
nature of post is permanent.
Lordship.
But was he absorbed?
Lordship. Yes, because lordship is not revert back to the author. Even he filed a petition before this honorable court, lordship. In all that time, he is pleased that he is a permanently absorbed in that particular department, lordship.
No, Mr. Indranil, you can't go back to Jorhat. You can't go back to Jorhat.
In that case, I have
Yes.
to be accommodated at Gauhati University.
Ah.
Because the law is, your lordship is aware of the law. Law pertaining to lien, there are two fundamentals. One is that a substantive employee cannot lose his lien. He has to have a lien either at place A or place B. That is what has been time and again interpreted.
It can't be for an indeterminate period. So, कौन सी law आप बता रहे हैं? It can't be for indeterminate period. Otherwise, that post remains vacant in the parent organization.
Your law-
कहाँ से law पढ़ लिया?
That is what is the law, madam. Well, in my humble understanding, if your lordship will kindly have aforesaid, exactly same identical provision has been interpreted by Supreme Court that a person cannot lose his lien. He has to have a lien at some post.
Oh, he has. So when you get absorbed, then
I
you
was-
lien.
That is what I said. My learned friend is correct. Initially, when the Gauhati University released me, I filed a writ petition saying that I ought to have been treated to, because the word initially is used in the advertisement. That initially for a period of, if your lordship comes back to the advertisement. So that argument was negated. Giving me the liberty, if your lordship comes to the advertisement,
Just a minute, let us, before that, where is the letter of termination of his lien?
Lordship. It's a termination of lien, lordship. Page 160, lordship. Last page, 166, lordship. 166, lordship. Or lordship, 132 page also, lordship. Page 132 also. lordship. Anything, lordship? Yes, sir.
You should have asked for your absorption permanently. You should have asked for your absorption in Gauhati University permanently.
I did.
Because
madam.
that
was-
just a minute, because that option was given to you while you were granted lien for 1 year. That lien for 1 year, after that you returned. Or you resigned if you are absolved. The letter says so. So you should have asked for your absorption within 1 year, and then you should have resigned. You can't keep both the posts occupied. Once you are on lien, there will be no posting on that post.
But, may I just add one intervening fact? What had happened was, on the one hand, my lien was sought to be terminated. On the other hand, Gauhati University released me. So as soon as Gauhati University released me, I came before this honorable court, challenging that order of release and also asking for what has fallen from your lordship, that I ought to have been treated to be a permanent employee, because you say initially for.
No, but Mr. Indranil, you may be a victim of circumstance, but you should have anticipated that this can come.
Perhaps. I will accept on it.
You have.
It could have been,
dealt with
Because
better.
within 1 year, you should have approached the university for
True.
your absorption if you never wanted to return.
True.
If you are not absorbed, you should have returned. It is only for this that a lien is given to you. But that you lost because you got a stay order, whatever. But then here there is no absorption. You want to remain at that place, leaving your lien substantive posting. So what can we do? What has the university to say?
If your lordship will kindly have.
आप यूनिवर्सिटी को पार्टी भी नहीं बनाया.
Huh, what university?
Who appears for the university?
No, because the challenge against the university's action was already lost, man. All the way up to Supreme Court, I lost. If your lordship will just allow me to
आप
place,
देखो, it is- कानून से कुछ नहीं है. We can't do anything with
No.
law.
it will be my endeavor to satisfy your lordship that is what the learned single judge has held.
What are you reading? Let
If
us-
your lordship will kindly take up
You have lost.
FRSR.
Mr. Indranil Chaudhary, your wisdom in geology has perhaps led you to a hellhole. But this is what happens when you have a lot of expertise in science subjects. It's your idea about civil administration.
But I see some light at the end of the
Light we want to see. Because
Your lordship will kindly have
let
the
that,
FRSR.
let that person be anybody. But if he loses his job like this, with such qualification, we are feeling troubled. Therefore, otherwise it's very easy to allow the prayer of Mr. Gogoi.
Well, in fact, I'll place the judgment as has been. If your lordship will kindly take up the FRSR.
You are responsible for your path to hell.
We get it. Page 35.
Did you make any request to the Gauhati Engineering College for extension of lien?
No, once I lost in the other battle one against Gauhati University, that's when I approached that now I'll place all those facts, madam, but before that. A judgment will give. 2009 4 SSC, 2009 4 SSC 7.
Yes.
My lords will have FR 14 capital A. In my book, my lord, it is at page 35. 44. FR 14 capital A, small a. my lord. Government servants lien on a post in no circumstances be terminated, even with his consent, if the result will be to leave him without a lien or a suspended lien upon a permanent post. Now B, a government servant's lien on a post shall stand terminated on his acquiring a lien on a permanent post, whether under central or state government, outside the cadre in which he is born. So if I did not acquire a lien in Gauhati University,
Just. Mr. Indranil, you'll have to reread this.
no, instead of my lord before I,
You are going wrong.
it has been
You're
interpreted.
going absolutely wrong, Mr. Idani. You can question me if
My-
we are wrong.
My lord, my lord,
You're absolutely wrong.
my lord.
This termination again, is the same thing what in the earlier case.
In that case, my lord, what happened, what?
सुनिए तो सही.
Oh, my lord.
Chaudhary, please, we are trying to help you out. Let us not go the wrong way.
My lord.
We are not trying to show you any road to garden path. But we want this termination refers to a termination midway. You're not understanding this. This termination, this is in a different context altogether. This is with respect to employment in a foreign employer, under a foreign employer. But the concept is that suppose you go on lien to Gauhati University. This lien is for a period of 1 year. They will not terminate you unless you get absorbed there, because one post has to be there. But in your case, you were asked to come back. There you were not absorbed. They released you after using your services for 5 years.
No, for 1 year.
For 1 year only.
They used,
And here your termination, it was over. They have not terminated it. It has expired. You have not resigned, so it has expired. 1 year has passed. So this FR does not relate to you.
no, they terminated. Jorhat terminated.
ये एक साल की थी.
No, Jorhat terminated, passed an order terminating.
After one.
Your period of your period.
I appreciate what has fallen from your. My period of lien was for 1 year.
No matter whether you appreciate or I appreciate you, it is not going to help the client. The question is that we will not go beyond law. Now let me explore the possibility of having you employed at least. You're a
And in any case, he is about to retire in August. He is reaching 60 years. So
then no sympathy. He's lived his life.
we are always at your lordship's hands.
No, we are
I am
considering
just trying to place the
We are-
law as I have understood.
this FR is going to lead to a wrong, interpretation.
If it is a wrong interpretation, it is a wrong interpretation made by the Supreme Court, because there is a Supreme Court judgment.
Let us see Supreme Court. Don't say that.
Yes, exactly identical thing has been interpreted. 2009 4SS is 700.
Identical तो कभी होता ही नहीं है.
Exactly same, word for word, same rules involved. Paragraph 15 onwards, your lordship, the rules have been quoted. Word for word, the rules are same. And identical
1
facts.
second.
Citation was 2007. Oh, sorry, 2009. 4S60, second one.
This is what I'm saying. Mr. Chaudhary, you have to read it. You unhinged me for a second when you said that if this interpretation is wrong, then Supreme Court is wrong. What we are saying, only the Supreme Court is echoing.
My lord, the facts are exactly same, if I have understood.
Sir, not
Subject to
saying
correction.
that.
Subject to
There's no
correction.
difference. Just a minute. इससे फायदा नहीं हो रहा. Look at this. This is very difficult. I think you have understood what we are saying.
My lord, Otherwise,
You have
what?
understood what we are saying. नहीं ये नहीं है. This is with respect to Rajasthan service rules, where apart from that provision, there is another provision which says that a government servant's lien on a post stands terminated on his acquiring a lien on a permanent post. This refers to the absorption in the post where you go on a lien from your earlier post. Now with this, it stands terminated. You can't be left, in the lurch. Within 1 year, even on your asking, it could not have been terminated. But after 1 year, what is the period of this 1 year then, Lian? How can you interpret things which have, an effect which would not be in keeping with the whole period of duration? Common sense.
In that case, what effectively happens if
No,
we
if,
read?
if a termination, if there cannot be ever a termination of a lien on a substantive post,
No, I'm not
then
saying.
suppose an officer, suppose a professor of botany goes to Delhi in another college on lien, and there she is not absorbed. Here also termination is not extended, so it shall never end.
No, I'm not saying, not for a moment I'm saying that. What I'm saying, your lordship will kindly have a look at the facts. The advertisement says initially for a period of 5 years. Now, I get appointed. The nature of the post is indicated as permanent. But
That is against university, that is what?
I'm not, absolutely. So now, I'm just placing the background facts for the simple reason. Now,
Help you. Yeah, unless we ask the state, to show this deference to your education, beyond
No.
that we can't.
but law cannot be based on sympathy. So that I appreciate. What I'm trying to point out before your lordship,
Yeah, if you get any relief, it will only be on sympathy.
that here is a situation where they grant me a lien
For 1 year.
for almost about 6 months, they keep quiet. And Gauhati University does not do anything. Suddenly, Gauhati University issues an order releasing me. I challenge this before your this honorable
It
court.
was during that year period.
No. After 1 year, almost.
क्या इसमें बहस कर रहा है? इसमें बहस का क्या मतलब है?
नहीं,
यहाँ बहस का क्या मतलब है? Where is the situation which gets you any relief?
No,
See,
the reason is, my
one
lord.
thing, I mean, don't take us to those facts. You were appointed for a period of 1 year, for a period of 5 years. Correct. Post was permanent, but your engagement was for 1 year.
No, only the lien was for 1 year.
आपकी एडवर्टीजमेंट ही है 1 year की, तो आपको परमानेंट कैसे कर देगा?
That is where the confusion started.
Okay, advertisement was for 5 years and not a permanent one. Correct. So for 5 years, you did not get the lien for 5 years. And lien could be given for 3 or 5 years, depending upon the practice
Fine.
of the institution. You got it only for 1 year.
1 year.
Therefore, and you accepted it. You never asked for any extension. Lien is also extended if you don't get permanently absorbed in the other institution. Now, if the Gauhati Gauhati University would have released you within this period of 1 year, then perhaps you had every right to claim that you must be allowed to join. Lien remains in there. Question is that lien expired with 1 year. You did not make any request for extension prior to its termination. So the chapter is over. There, after 5 years, they say that we don't require you now. Now what happens? How you have yourself caused this misery come to you?
So,
इसको हमने सिंप्लीफाई कर दिया है फैक्ट सिचुएशन को. इस पर आप इधर बहस करें, उधर बहस करें, सुप्रीम कोर्ट दिखाएं, एफआर दिखाएं, बड़ा सिंपल है. Unless you reduce facts to, you have to use the judicial calendar in order to make it simplistic, in order to make it understandable. This is the tool which I use. Now, if you complicate, you lose out. If you simplify and straighten the facts and try and understand, this is for the benefit of the younger members of the bar. The court can never get misled if the court has the capacity to filter out the facts which are necessary for decision. Otherwise, we have all sympathies for you. You perhaps thought that your knowledge of geology will see you through, you will be absorbed. You did not. After how many years Gauhati University released you?
about 1.5 years.
5 years, 6 months. You could not assess your employer's intention of not retaining you for even 5 years.
But that is why.
So, but you should have been careful. You should have come to the Jorhat Engineering College.
I came immediately.
Came immediately after it was terminated.
After termination.
So,
Otherwise, what do I challenge? Because
no, what do you challenge is something else. You could have said that now I am seeking. What could you challenge this? You don't ask from us. Mr. Chaudhary, you could have sensed that the government, the Gauhati University is not going to retain you. Not going to retain you unless you, in fact, the better option for you was that you were appointed for 5 years. So they could not have released you before 5 years. Since the lien was only for 1, you had legitimate expectation of being absorbed because the post is permanent. That litigation you lost till Supreme Court. Now it would only be an act of grace shown by Gauhati Engineering College to admit you again.
That grace is not being shown, my lordship. That's how I am before your lordship.
The problem
Simple
is you have
facts.
not challenged that please extend my lien against your employer. Rather, you have said that please absorb me. You have no grievance against termination of your lien.
Well,
And the
actually-
lien itself says that it will be terminated automatically until unless you are resigned or
ये जो FR आप पढ़े हैं, the FR that you have read is different. You can't lose your lien on a substantive post without your being absorbed in another substantive post.
So that is what is happening.
Correct. But that is for a period of lien, not beyond that period. But suppose, just a minute. Suppose the Gauhati University does not understand the situation. How do you read a circular like this? And that also only for the advisory purposes. Suppose Gauhati University keeps you for 5 years, does not absorb you. They give you further extension. You think that further extension is absorption and you don't do anything for the extension of your lien and you claim it as a matter of hereditary right that shall always be with you. कौन सी कानून आप हमें पढ़ा रहे हैं?
In fact, my lord, factually I stand.
Sahib, the person was advised wrongly by some advocate who he would have consulted. He should have gone to DC. And why did you lose that litigation in Gauhati University?
All the way it was held that it was not a permanent.
It may not have been a permanent post, but you were appointed for 5 years, no? So you were appointed for 5 years. Why did they release you?
There's no reason cited.
No reason cited. So did you contest it?
Yes.
That because of this, I had the expectation. Otherwise, I lose out there. आप सुप्रीम कोर्ट से चले जाकर सब केस हार गए हैं और गुवाहाटी हाई कोर्ट में you won.
On one fact, I stand corrected, my lord. I did apply for extension of lien.
That was rejected. Did you challenge it?
That was never responded.
No, that was subsequent to your lien. It is on 38 of 2016.
पहले करना होता है.
No.
Yes.
Anyway, let us ask.
38 something, 38 of June, I guess, 2016.
कुछ नहीं कर सकते इसमें.
I'll leave it to your lordship.
Let
We
us-
are always at your lordship's hands.
Let us ask Mr. Gogoi.
They won't do anything. That I'm confident. Had they wanted, my lord, a MSc PhD from IIT Kharagpur, had they wanted my services, they would have certainly.
Don't display that kind of wisdom now, dear.
No, I'm not displaying.
You're not,
I'm talking about the government.
you have not displayed that wisdom.
Had I had the wisdom, my lord, each and everything that has fallen from your lordships would have been done by me.
In fact,
I did not have that wisdom. That's why I am struggling before your lordship.
you were very good in Gauhati Engineering College where you were teaching students your subject. You chose an administrative post over teaching post. क्या करें इसको admit or not करें छोड़ो.
And I had
Where are
only
you
said.
now? Where are you at the moment?
No. Without a source of livelihood since 2016. 10 years.
It's all your own page.
There are times, that is why perhaps I try to understand Article 226 in that manner. That is why it is called extraordinary jurisdiction. Perhaps this is where your lordships reach out and that famous Dwarkanath judgment, paragraph 4. Wherever there is injustice, your lordships exercise jurisdiction under 226 and anything.
142 का powers नहीं है.
Great, but that is a constitution bench, man. Dwarkanath is a constitution bench.
Mr. Gogoi,
Lordship.
just find out.
I'll
You
try.
you must have some deference for education, for degrees, for
I'll try. Otherwise, also, Lordship, just I indicated Lordship.
just check up with your client.
Lordship, I'll do. Otherwise, just I pointed one thing, Lordship. Before Gauhati
You have a
University,
very strong case on merit.
Lordship, before Gauhati University, he was also Lian in another administrative post in another department for 3 years, Lordship.
You know, scope, leave that background.
Lordship.
Can you do something at the fag end of his career?
Lordship, I'll.
Just check up and say, otherwise we have already stated that just now.
Lordship.
In fact, there is some miscalculation on his part. And that is understandable because he is from science subjects. He does not know administrative,
Lordship.
nitty-gritties.
Not some miscalculation, all miscalculations.
He should have, and he would have been successful in questioning the decision of Gauhati
Lordship.
University
No.
in releasing him within 1.5 years without any reason.
No, Lordship, he is released after 5 years, Lordship.
No.
After 5 years. 5 years, 6 months, Lordship. 5 years, 6 months, Lordship. No, Lordship, it's a wrong statement. After,
I'm stand corrected.
Yes, he continued even after expiry of the.
yes,
lien,
Lordship.
Without challenging the lien, finally passed.
तो आपने अपने हमारे यहाँ बिहार में कहावत है अपने पैर पर कुल्हाड़ी मारा है तो
हम भी बोलते हैं।
पैर पर कुल्हाड़ी मारा है तो how can I help you? I can only stop the neurogenic shock of stopping the bleeding from your body. वो gangrene हो गया है बॉस क्या करेंगे? It has turned into an abscess. अफसोस है. I'm very unhappy upturning the decision of the learned single judge and showing you the door. वो आज नहीं करेंगे. We don't want to do that. Today we will not do it. You find out, Mr. Gogoi,
Lordship.
and don't take a rigid stand.
Lordship.
Don't behave like a generous employer
Say Lordship.
unless he has created nuisance there.
There's no allegation as such. He's a very humble, down to earth man.
You want to be in and around Goa.
No, my
On lien.
We are very unhappy with
Then in
this.
the administrative.
Probably he did not understand. I can understand.
40 years before that, Lordship.
Probably he did not understand what he was doing.
that is true.
From 2010 onwards, in the Gauhati.
I entered the fray only at the final hearing stage. Before the thing.
Otherwise, he would have
And
said that.
I also felt the same way.
Just see what can be done. We don't say anything.
Lordship.
We'll only adjourn the matter.
Lordship.
Now let me see something so that he also has something to ask from Gauhati.
The lordship is fixing a date now.
No, they are giving our peace of mind here.
One.
So that Mr. Gogoi has something to handle his request.
I'm grateful. man.
We have heard Mr. K. Gogoi, learned advocate for the fallen state of Assam and two others, and Mr. Indranil Chaudhary, learned senior advocate for the respondent number 1. While serving as an associate professor in geology at Jorhat Engineering College, Jorhat, under the government of Assam, the respondent was appointed as a director of the College Development Council at Gauhati University on a fixed term basis for 5 years, while retaining a lien to his original post in the Jorhat Engineering College for 1 year. He did not return after the lien period expired, nor was his belated request for extending of lien responded to. After serving the Gauhati University as director of the College Development Council, he was released after 5 years, which release order was questioned by a respondent, but to no avail, as his employment only was for a period of 5 years. Within the aforenoted period of 5 years, the respondent ought to have assessed that his period of lien was already over. And in case of any denial of further extension in Gauhati University, he would be rendered jobless. So it was only after his release from the position of the Director of College Development Council at Gauhati University that the respondent tried to rejoin on the post of Associate Professor in Geology at Jorhat Engineering College, which had given him lien for only 1 year, notwithstanding the fact that the respondent had obtained the employment in the Gauhati University for a period of 5 years. For a period of 5 years. Mr. Chaudhary, representing the respondent, submits that with such high qualification of the respondent number 1, such a difficult stand, such a rigid stand ought not to be taken by Jorhat Engineering College. And that without claiming any back wages or other benefits, he ought to be taken in service for 2 reasons. Semicolon. One being not to waste his talent which he has acquired over a period of time. And the other for his having remained with a very short time in superannuation. Short time to superannuation. Mr. Gogoi, Learned Counsel for the appellant shall get back to the Jorhat Engineering College administration and would explore the feasibility of accommodating the appellant, considering his academic excellence and his having offered no academic excellence. Let this matter come up for consideration on. We give you 4 weeks. Find out. Don't ignore the talent. Come समय के लिए back wage, he will not ask for back wage. आप पूछिए उसको.
I'll do.
Can I pray for a date, man? If it is not inconvenient, 2nd of June, that will be.
Giving you a date. We'll speak you a date.
9th June.
Yes.
My lord, the petitioner before your lordship is a public spirited person, lordship, and he filed this instant PIL lordship regarding public auctioning of the seized Erekanars lordship, which is unfit for human consumption.
No, that's
to the public law.
We wanted, what affidavit have you filed? Sumitra, you are handling this matter?
Yes, my lord.
What affidavit have you filed?
This was filed on 11/4/25. My lord, here we say that
Page?
lordship, page 61, paragraph 8. Art stand. I say that the claim that the SOP mentions that the betel nuts are eligible only for industrial buyers and not for public buyers is incorrect. SOP specifically states that the betel nuts should be only be used for non-edible industrial purposes and must not be consumed by humans. However, there is no provision in the SOP that restricts eligibility to industrial buyers alone.
That is the concern of the petitioner. That if you don't restrict it to industrial buyers only, of course you don't have that. Otherwise, you would not have issued auction notice to one and all. Question is that there is great risk of that being, brought back in the market for human consumption. So you're a welfare state. No, you can always make that. So that stand of yours is not a very good stand, I must say. Because you seize it for the reason of that not being edible.
Yes.
Correct. And you are selling it in the market, open market. You're auctioning it. And you know how unscrupulous these persons can become.
Well, I may most humbly draw your lordship's attention to clause 15 at page 24 of your lordship's brief.
15.
Yes.
This 15 is the prayer.
No, my lord, page 24, clause 15. This is the SOP for disposal of betel nuts.
Page 24. Paragraph?
Last paragraph. It may happen that even if the seizures are unfit for human consumption, there may be owner or a claimant who may submit a plea before the court that they would use such betel nuts as raw material for manufacture of some non-native, and that the same will not be used for human consumption. In that case, the superintendent of police could get a claim verified, report to the court. If the claim is genuine.
So are you applying it? Across the board, are you applying it? Are you enforcing it? Are you taking the affidavit from the buyer that it shall not be used for edible purposes?
Yes, my lord, that is there. That is there in the SOP itself, my lord.
Where have you said SOP is all right? Where have you said that in auction? That anybody who would be successful in auction will have to give an affidavit that it shall not be used for edible
Lordship
purposes.
grants me a
There is
moment.
the provision in the auction notice.
Yes, my lord.
But the fact remains is that, lordship, the SOP does not allow the state to auction the same, lordship, which is unfit for human consumption. Only that may be destructive, lordship. Because
that we will not have.
because lordship, in the SOP itself, if there is a claimant,
That
lordship.
destruction order we shall not pass because it may not be good for human consumption, but it will be good for some other
Yes,
industrial
lordship,
purposes.
that may be, but that should be restricted, lordship. Otherwise, lordship.
It is
there
what
is
we
a-
are asking. Don't
Yeah, yeah.
unnecessarily be sensitive about
Okay.
it. We are taking note of it. We are only saying, no, you have flagged the correct issue. Now we want to be doubly assured that the SOP is being followed. Where have you said that the SOP is being followed to the letter and spirit? And every purchaser, every auction purchaser is under an obligation to file an affidavit or to give an undertaking.
Page 28 of your lordship's brief, my lord, clause 9, the last paragraph. Interested persons party must submit an undertaking bond in notary affidavit regarding usage of auction betel nuts only for industrial non-edible purposes. A photocopy self-attested of the trade license related to purchase, sale of betel nuts, GST registration related to betel nuts, Aadhaar, voter ID, PAN, 2 numbers along with the tender form. This is ingrained in the SOP itself. In the notice, my lord, option notice itself.
I think paragraph 17 and 18 of their counter affidavit. Stick-ons. Stick-ons. This is auction notice. This is the paragraph. This is the auction notice and where is the SOP is that page?
SOP is at page. 24, the relevant clause is at page, starts at 23, my lord. SOP starts at page 23. The auction notice starts
Mr.
at
Borbhoya, this is the maximum that we can ensure. Taken. We have heard Mr. Borbhoya, Mr. N.H. Borbhoya, learned advocate for the petitioner, and Ms. Sumitra Sharma, learned government advocate for the state. They this PIL has been filed on the observation of the petitioner that the Burmese betel nuts, which are not fit for human consumption, are being indiscriminately auction sold with an inherent danger of the same being brought to the market for consumption by gullible purchasers, gullible customers. A request therefore has been made that it must be ensured that such seized Burmese areca nuts be, if required, auction sold to only industrial purchasers. Be only auction sold to the industrial purchasers. The petitioner has brought to the notice of this court 2 instances of auction notice of seized Burmese areca nuts, which are in violation of the SOP made in this regard. The allegations have been countered by Ms. Sumitra Sharma, learned government advocate, and it has been submitted that considering the risk and the dangers involved in disposing of such seized Burmese areca nuts, a standard operating procedure for disposal of such nuts have been formulated in the year 2021 only. One of the conditions, one of the procedural safeguards is that even the claimant who takes a plea that such areca nuts would not be used for edible products, but would be used for other purposes, would be required to be verified and to be given back to him only if such a claim by such owner, or in case of auction sale, the buyer is found to be correct. Is found to be correct. Even in the auction notice, even in all auction notices, Ms. Sumitra Sharma contains that a clause is incorporated that any buyer would be required to submit an undertaking / bond in notary affidavit regarding usage of auction betel nuts only for industrial / non-edible purposes, with a self-attested copy of the trade license related to purchase / sale of betel nuts, GST registration related to betel nuts, etc. Aadhaar card Aadhaar cards, voter ID cards, PAN cards, and passports are also required to be verified. Stop. In that event, if an undertaking by a buyer is not respected, is not followed, he can easily be traced for any penal offense. For any penal offense. In fact, the minimum reserve price also is fixed in the auction sale notice. The affidavit filed on behalf of the respondent state clearly specifies that the police department is exercising consistent vigilance in monitoring and preventing any illegal areca nut being smuggled in the state. And if at all, if at all it is brought in the state, those are seized. And it is always ensured that if at all it is to be auction sold, there will be strict adherence to the SOP referred to above dated 16/9/2021. The promise of the state is that it has always been, and in future also it shall be, meticulously carried, it shall be meticulously meticulously adhere. The provisions contained in SOP shall meticulously be adhered to, which will guarantee that the seized nuts are not used for human consumption. All steps in the process have been taken by the state. With such statement made on behalf of the state, we only trust and hope that the areca nuts, that the seized areca nuts, non-consumable areca nuts, are not sold to public for consumption in any circumstance whatsoever. This writ petition stands, this PIL thus stands consigned. Deeply obliged, Lordship.
Right.
Both the writ.
Item 12.
Yes, Mr. Naik.
Milord, this is a PIL pertaining to the havoc created by floods or waterlogging, particularly to the area.
I know, Mr. Man.
Yes.
You have rightly pointed it out.
Yes.
We have seen it during last week.
Yes.
When there were rains, nobody could cross any area. It
Milord,
was flooded. I mean, these kind of rains are expected in the state of Assam or in the northeast.
it is normal.
It's
It is
quite
normal.
normal.
And it will gradually, it will start further. Thus rains.
Now, Mr. Naik, recommendations were made by the High Powered Committee.
Well, yes.
No, in
We have,
fact,
we have said
Lordship-
so in our earlier order that recommendations for sure were made.
Yes,
But then what is being done now?
Lordship, one affidavit I have already filed, Lordship. If
Have you
Lordship-
given a copy to Mr. Mantha?
Yes.
Yeah, for this, Lordship. In
I have
fact,
got it.
they
We have replied
they have
to
funded-
also.
Yeah, they have also replied.
Yeah.
That is probably not in that.
Let's see your affidavit.
Lordship, in my affidavit, Lordship, I have basically annexed two documents, Lordship. One at page 91.
Just a minute, let us see. what you have said. Now, the affidavit at page,
Page 95 is the action.
page 74 to 80 is nothing. I don't expect anything more than this from an officer.
My affidavit starts from page 85.
Let's see that.
Lordship, at page 95, Lordship, I have annexed one action taken report.
What have you said? So we are the same person.
It was in compliance with your
It's
Lordship.
not worth reading.
Action taken report of Lordship. Lordship, may kindly see the measures we have already initiated.
Where are the suggestions given by the committee?
Lordship, in fact, Lordship, this is also a person to a committee report.
Right. We got no suggestions what have been done pursuant to that.
In the, for that Lordship will come to page 91. Page 91. Lordship, in compliance of your Lordship last order, Lordship, a meeting of the all the concerned.
Asking for that.
Yes.
Just tonight, I'm not asking for that. There was a committee constituted.
Lordship,
Looking at the aspects.
one committee was constituted. Lordship, may kindly see the report at page 37. Lordship, this was a report submitted on behalf of the Rukmini Nagar area residents.
They have given some suggestions.
Resident.
Where are those?
If Lordship comes to page 40, Lordship.
40.
Yes.
Yes.
Top Lordship. Lordship will see causes of sudden flooding, Lordship. Lordship, may kindly see the reason. One, huge influx of water from survey. Survey is the area, Lordship. Survey to Last Gate and Secretariat via Valtola Road, 80 feet road, supermarket, so and so. So basically, this is a Lordship low-lying area, and all the water comes from the surrounding areas, Lordship.
It was
From
never in low-lying area.
Lordship,
Earlier.
I have checked the altitude map, Lordship. Its altitude is around 50 to 55.
This
Lordship.
Rukmini phenomena is a recent phenomenon.
From 2002, Lordship.
Ah.
Yes, from 2002, they have.
Whatever it is, now tell me, these are some proposed solutions, immediate and long term. For
Lordship,
immediate, what have you done?
immediate Lordship, Lordship may kindly see page 95, Lordship. If Lordship comes to the action taken report, Lordship. One, Lordship, dredging of Bahini River. This is that particular area only, Lordship. Dredging of Bahini River. GMC has commenced dredging of Bahini River, riverbed, along the stretch from Pipco Point to Hanuman Mandir, Ganesh Guri. This is exactly the area concerned, Lordship. To restore carrying capacity and ensure free flood of storm water. The water targets removal of seal deposits as well as excavation of riverbed, responsible for stagnation and backflow into internal drains. Two is desiltation, Lordship. trees, desiltation of inner drains, lordship, connected drains.
Yes, sir. So if you have taken all this action in January, then why did it happen? Water logging and of such serious nature.
I think lordship will appreciate, lordship, the recent flood, lordship. It was because of, lordship, this was not an abnormal rain situation.
You
This is not
this kind of rain always.
No, lordship, lordship will see the annual rainfall in Guwahati, lordship. It is around 1,015, 20. That is the the normal rains, lordship. This time, lordship, within 3-4 hours, lordship, it was around 200 mm, lordship, rainfall. So it was not a normal rain situation, lordship. And that is that this time, lordship, that was the only time so far flooding took place, lordship.
Yeah, all these action taken report is of no consequence of the citizens. Face this kind of flood. Schools had to be closed. One of my judges, he was coming from outstation. He could not even reach his house. I could not even arrange for his guest house accommodation. He had to stay overnight in a friend's house. And then from there, because he had some dress with him, he came to court.
All over Guwahati, that situation.
All over
Yes, not just.
these cases which were reported to me.
Yes, I admit, lordship, in Rupinigar,
Some staff had to stand on the road because he had gone to some place for about 6 hours and he fell ill and all my work got disturbed. With his water soaked.
in fact, lordship, many of our colleagues, lordship, those who were in the birthday party, lordship, they reached home around 3:30.
Something about it. All this paperwork is not going to help. It doesn't satisfy. See, we can be satisfied on paper. That well, Mr. Naik has given us this action taken report. But then this is not help. You have to do something. You can't stop the rain and we can't pass any mandamus to Lord Indra to stop raining like this. But then you have to find out some way of, mitigating the troubles of people.
My submission would be,
January fail kar diya. All action taken has failed. We understand it was not a normal rain. We discount
Yes.
that.
That is
We discount that. Are we questioning you? Are we putting you with the dog? No, not at all. We are not doing it.
Yes.
We are not raising the blame on you. We are not. We are only requesting you. We are asking you. We are urging you to do something for your own citizens. We are not putting you in dock. We are not prosecuting you for anything. We are only saying that if you think that this is good enough, nothing more can be done. Well, then it's all right. I don't think, Mr. Naik, you as a additional advocate general would be satisfied with the efforts and the impact of those efforts. If you're satisfied, then I don't have to say anything.
But so far as
Now, let us not adjudicate it. You tell us, is this satisfactory? The end result, the net impact of whatever you have done was rendered completely negative. क्या कर सकते हैं वो देखिए, call for all kinds of scientists, engineers. They are only busy doing something else. And desiltation you will start doing now. When tomorrow there is an orange alert or red alert for heavy rains, what will you do by desiltation?
Mr. Nayak, by the way, I'm just the permission for desiltation. What they do is after desiltation, that they keep those silt in the road.
It
goes back to.
Why can't you take it together? One vehicle will come and do the same thing, and after 3 days, some vehicle will come, and by that time again rain, and it goes back to
peculiar way. I have seen in my state, these municipality workers, they clean the road and they collect the garbage in the middle of the road.
Yeah.
It looks clean for a few hours and then everything, again is spread all over. I've never been able to understand this. You desilt and keep the.
But lordship, as have been conveyed to me, lordship, these are effective measures. All these measures are effective measures. In normal rain, lordship, in a situation of normal rain, lordship.
Don't take this a stand, Mr. Naik. We expect the state to, further do something. It is for you to suggest to us. It's not for us to suggest. We do not think, on paper, this is okay. This is in tune with what has been advised. But it is not working. So there must be something amiss somewhere. There's something amiss somewhere.
So otherwise, Lordship,
इसको आप don't take it as a adversarial litigation, please, Mr. Nayak. You don't have to justify yourself. You have to treat yourself as a person, as what is that called? The man on the Clapham omnibus.
yes, Lord. But in
You
normal,
have to treat
normal,
yourself. आप तो ठीक है, आपकी बड़ी गाड़ी होगी. You can always cross that road overflowing with water. If not, you will get another car. You'll walk for some distance. You'll have another car parked on the senior most government council. Consider yourself to be a person who had joined bar some 20 years,
Lordship, this
25
Rukmini
years ago.
Rukmini
would you
area
have
is
done?
just on the other side of my residence plot. In my side, Lordship,
he
there is no
said-
flooding,
Well, you are not getting stirred up.
or
That
just
is the
on the
only
other side.
difficulty.
Lordship. So my submission
I
is,
would stay here for my entire life in Gauhati.
yes,
But since I'm here, I am concerned for the people of Gauhati. Do something. I'm not happy. See, these paper desiltation of stormwater drain, desiltation of diversion drain. On paper, this is all right. We can close the petition if you so want. But is it going to help? Has it helped?
yes, Lordship. In fact, it is the understanding of the authority. Lordship, these are effective measures, and in situations of
Because
normal
you
draining.
suggest that we should close this petition. Nothing
Lordship,
beyond can be done.
Lordship, in normal situations,
Nothing
Lordship,
beyond.
water drains out within a period of 2-3 hours, Lordship. That is the, I mean, satisfaction we are at that. Lord.
We are not.
But so far as last rain is concerned, Lordship, yes, Lord.
How many times will I repeat, Mr. Nayak, that you are not at the opposite end of the spectrum. You consider yourself to be part of all of them. You're not answering on behalf of this
My
case.
only concern is, Lordship, I am not the authority on this point, so I am dependent upon the concerned department, Lordship.
बुलाइए और वो कहिए कि I don't want this. The court has taken, I mean, let us be serious about it.
Lordship.
You tell them that the court is very serious about it. Next time onwards, the court will not hear me. He will ask for you all. What kind of degree they have if they can't even mitigate this?
Lordship, in fact, pursuant to your Lordship ordered the
You're
8/1/26.
not removing yourself from the position of additional advocate general. That is the whole difficulty. I have told you repeatedly, we are not questioning your intentions.
No.
We are not putting you to any, I mean, we are not keeping you in dock. How many times you want us to tell you? आपको कोई मैं चार्ज नहीं कर रहा हूँ. आप अगर satisfied है तो हमें कुछ कहना ही नहीं है. Then I don't think I'll be helpless then. Then in that case, I will only call the chief municipal commissioner and say that you better be in jail. Better be in jail. People will be satisfied that something has been done. You don't force us to say that. No? आप कहिए उनको, you are, of course, you are a lawyer. You would go by the affidavit, by the inputs that you get. But you tell them that this does not satisfy the court because it has shown no impact. Find out. Tell us what can be done. The government is ready to spend money.
Yes.
ये कहेंगे आप ना कि आप उसको जस्टिफाई करेंगे भाई जो कर सकता था कर दिया अब कुछ नहीं हो सकता. अगर ऐसा अप्रोच इंडिया में रखने लगे हैं, हर स्टेट रखने लगे हैं, तो कुछ होगा ही नहीं.
In fact,
आपको पता है कोसी is a river which flows through the state of Bihar. It is called Sorrow of Bihar. As long as the government was not very serious about it, every year thousands of people used to get displaced. Today, because of the efforts of the courts and the political will, because large number of voters are in the northern belt, now there is a bridge over that river. And in case of need, different tents are erected and things are, in fact, an attempt has been made to change the course of the river and more of it now goes to Nepal. There has to be a political will, there has to be an administrative will, there has to be understanding, there has to be, a sensitive heart. Saap kaatne, there were thousands of deaths because of snake bite, those water snakes.
no.
Only when the government took special care, situation improved. Now they could have very well said, which they were saying, that this is sorrow of Bihar. This is geographical calamity which we are facing. What do? We can't change the river course. But with some ingenuity, with some seriousness, I think a lot of problem has been tackled. And I have seen that. I hail from that area where my agricultural land gets flooded because of Koshi.
Oh, here, no.
We are aware of it. In fact, most my personal lands are at a high pedestal. We open it for people for good 3 months. That make your hutments and stay there. Because nothing is grown on that. We don't lose out on anything. We just permit people to go.
Yes, I
and
understand.
stay there.
Lordship, in that situation, Lordship will give me some inner Lordship. Let the petitioner also suggest some measures,
No,
Lordship.
he can't. What will he suggest?
In fact, one report he has.
You do one thing.
Lord.
We will not write anything against the efforts taken. We will not. We don't consider
No
it
effort
to be
in
adversarial.
no
That
practical.
Mr. Mahanta is also not asking for. Will not say. You find out. You call your authorities and tell them that, well, all this effort you have taken, but it has not shown any impact. Now, what else can you think of? At least talk to them like this. I would expect.
Yes, sir.
We are not questioning you. We are not putting the blame on you. We are not shouting at the officer. Nothing. All these efforts have failed. अब इसको देखो कैसे करना.
In fact, if I may add, Melo,
ऐसा है परीक्षा में एक बार फेल करने से दोबारा नहीं परीक्षा लिखो ऐसा तो नहीं है.
it's a name.
You would write again.
Yes. The,
This has failed. This is the recent days experience shows us that this effort has failed.
the very effort was not that sincere effort, Melo.
अच्छा ये तो पूरे आसाम की भी बात नहीं कर रहे हैं. ये रुक्मित गांव की बात.
Rukmini, only a particular area.
This time I think it is for more than 4 days.
Yes. Submerged underwater and knee deep water. Well, the waist deep water.
आप अभी you take yourself away from the position of additional advocate. As a citizen of Gauhati, as a resident of Gauhati, think like that. With no institutional support, if you think that a common citizen, a man, I mean, on the Clapham omnibus, does not face troubles during rainy days. Good enough, then I leave it for the other judges who are not from, I mean, other judges who are from Gauhati to look into it. If I feel that way, I think the others would feel even more strongly. Only let it be handled by TV2 then. ये तो ऐसा हो गया ही नहीं ना. You are testing the efforts. We are appreciative. You have done everything. It has not helped. What to do? मैं बहुत मेहनत करके आपसे बहुत बहस करूंगा और जजमेंट ही नहीं लिखूंगा तो क्या होगा?
In fact, this is not a matter, Lordship. Well, I will take it as an adversarial Lordship. That is not the matter, Lordship. But what I can do, Lordship, I am dependent upon the opposition.
Suggesting. Forget Mr. Mohanta. Let him not suggest anything. I am suggesting. We are suggesting. You call the authorities. Tell them that all this, the French read. They were very happy. They said that, well, paperwork is excellent. No difficulties, no questions can be asked. But it has not helped. That is for sure. Now find out what can be done. At least you can do this.
Lordship, in fact, pursuant to your Lordship, last order, Lordship, I call all the departments, Lordship, in my chamber, Lordship. They huddle, Lordship, and pursuant to that meeting, Lordship, a special team was constituted. That special team prepared this report, Lordship. And this action taken report was also. Lordship, I will again have to call them.
Tell them that they are no good.
Yes, sir.
They should take, expert advice from other states. Do something. We are not very happy because it didn't work out. It didn't work out.
Yeah, I understand. Yes.
Somehow the other, I was not there in this city of Gauhati on that day. I was traveling.
I understand, Lordship. I
was
understand.
told by everyone. The moment I landed here, I was told by everyone that all this had happened in 3 days. So please, not that I come from a place which has very good civic abilities. I'm not saying that. No comparisons. Even Delhi. Mild rains and even the main roads get flooded.
Everywhere,
Is
Lordship.
that a
Even
solace?
Bangalore, Lordship, same situation.
Is that a solace? Bombay. But it is not a solace, no. We can handle because we have lesser footfall.
Lordship,
You
what I
may think that
understand, Lordship.
Guwahati city is bludgeoning with, I mean, it's overpopulated, but compare it with other populous states. There it is very difficult. Here at least your numbers are less. कुछ तो करेंगे. And plus, I think नदियां हैं अगल बगल इतने streams हैं. If all are, activated, the channels are activated, I don't think.
Channels are encroached, my lord, they have not removed it. There are clogging. This is the difficulty.
Interest लीजिए, Mr. Naik. And you will be happy by the end of the day when you come and tell the court that I have told them and I have ensured and I have personally monitored. This time it shall not happen, or even if it happens, it will be on a much lesser scale.
Yeah.
You'll feel happy. God has given you this position where you can do something for citizens.
Yes. Lordship, my submission will be ultimately, Lordship. Rain, we cannot stop. So flooding cannot also be stopped. Lordship, no, just 1 minute.
Lord Nayak, let us not proceed.
Lordship.
Who can do what now? But my lord, Chief Justice has given a suggestion, you talk to them. If necessary, some expert, take it sincerely, not time this kind of.
That is what I'm submitting. Lordship, flooding cannot be stopped, but our effort will be
To mitigate,
bring it out.
to lessen,
as early as
to lessen
possible.
the,
That is
lessen
fine.
the
That is what
impact.
I'm submitting. Yes, Lord.
lessen the impact. Oh, कहेंगे flood को नहीं रोक सकते, rains नहीं रोक सकते, तो मैं कोई mandamus थोड़ी issue करूंगा rain god को.
Lordship. That will be our effort, Lordship. And
My lord, had there been some sincere effort, way back in July 2024, the expert committee that was created by the Department.
What
of
do I say?
Housing, they have given.
Mr. Naik, considering the efforts that you've taken, you called people. I don't even want to say that all these efforts have failed. I don't want to say that.
Yes. Because no such attempt was made, in fact.
अब आप ऐसा करिए, we are not saying anything. You tell us on the next day what do you propose to do.
Lordship, I will again have to call a meeting.
Yes,
of the
please.
concerned
Please do that.
is the-
And we are not recording anything because, see, it serves no purpose in listing what you have done and then giving a comment that all this did not work out.
That is one. Lordship.
Why do we do that? If we have told you that it is not an adversary litigation, let us not record our displeasure about this. You've done. We are not doubting that you did not do. You did. But it failed. No, make another effort. See what can be done.
Lordship.
We are keeping it after 2 weeks. We are not giving a long date. You tell us what have you thought of.
2 days, 2 weeks, Lordship, very soft. Lordship.
3 weeks.
Lordship,
See,
on
we are not
fourth,
waiting for
Lordship,
the rains to
that
come.
is
No.
coming.
Mr. Nayak, why this is the season
I understand.
where we
Lordship.
can activate and you
Yes.
also get activated. So I think the short date is better. You may at least after 2 weeks come and say that this is, we have proceeded.
Yes.
Then we'll again adjourn for 2 days. It's not a problem.
How you
Otherwise,
start?
according
At least.
to me, it's a continuous monitoring. and report.
How we will not be closing it because it will be cruel to the people of Gauhati if we close this petition. It will be cruel.
Lordship.
I am not recording anything that this has failed. I am not recording. I am only orally observing.
Yes.
Because what is the purpose of making you feel uncomfortable in court? That is not our purpose. We only want you to be sensitive enough to go back to the authorities again and say that this has not worked. Kagaj, I don't want any paper justification. I want the result. You can say that. With the authority of the state, you can say that. Or if you don't want to say, you call those people before me. We'll see what kind of an expertise they have. And we'll have them understand how things can be managed. We are not doing it for the reason that we don't want to be unnecessarily harsh. We leave it to you. If you can't do it, frankly tell us that these authorities, these officers, they say that this is the maximum. Call them. They say that the Chief Justice will like to talk to you.
Yes. That will be the
We will
ultimate,
say.
my lord. I think that will be required.
But then we trust you, Mr. Naik. We trust your skills. We trust your sensitivity. Do something about it.
Lordship.
We'll not write anything adverse.
Yes, sir.
We are not interested in writing. We want good impact of your efforts.
Lordship.
Okay, let this matter come up for consideration again. on. We are keeping it after 3 weeks. After 2 weeks, you can at least come and tell us that you called all those authorities and said that this has failed.
The things
Now
have
they
moved.
must think about other things. ये तो कह सकते हैं.
Yes,
Definitely,
तो मैं 2 weeks के बाद लगाता हूँ.
Lordship.
After 2 weeks.
well,
18th May. Supplementary list, item 1, matter pertaining to Kohima bench.
Yes.
Now, please, your lordships. Lordship, here this review petition has been filed for review of the judgment and order oral dated 4 December 2025, passed on and read appeal 8 of 2023. The relevant judgment is batch 31, Lordship.
Yes.
Lordship, this particular writ appeal was dismissed solely on the ground that the case is covered by Nishibi's Achumi's case, Lordship. But in Lordship, why the present applicant petitioner is before this Honorable God is that, Lordship? Then Nishibi's case, Lordship, it was dismissed solely on the ground that on technical grounds, Lordships. Firstly, the petitioner in Nishibi's case died while in service. Secondly, the wife of the deceased claimed the recoloration only after a period of 12 years. And then at the time of the petitioner's husband, well, at the time of his death, who were senior to the deceased employees were regularized only in the year 2009. But that here in my case, it's totally different. Why? Because the petitioner's husband had already served 35 years length of service, and his right for consideration to be regularized has already been accrued during his lifetime. And then secondly, as the Lordship is aware, two of the juniors who were retired on the same day along with the petitioner, they were given the regularization. And then thirdly, I have Annex 1 order at page 120 Annexure 7, where on the hearing day, Lordship, similar writ appeals was listed before this Honorable Court, and then this Honorable Court has passed an order at page 123. May I read, my lords? Page
Let notice be issued to the respondent on steps being taken by the petitioner within a period of, who appears for the state of Nagaland?
Lordship, I am for the respondents.
All the respondent.
Yes, Lordship.
What's your name?
Vishukriya.
Vishukriya. On screen, you're not visible. Otherwise, we not have asked for your name. Notices, let notice be issued to the respondent. Notice is accepted by Ms. Shukre, who shall respond to this review petition by the next date. Re-notify on. We give you 2 weeks.
Lordship.
3 weeks.
Lordship.
Lordship.
3 weeks. Paragraph 14 of our judgment gives the answer, but he has brought certain documents on record.
Otherwise,
which espouses a different view. So let him have the satisfaction. We will hear it. We'll just find out and tell us.
or otherwise, Your Lordship, this review is not maintainable. Because whatever order we have passed, this is in pursuance to the court's direction.
We are not on that.
Lordship.
Paragraph 14 of our judgment, which is under review,
yes.
That gives the logic and reason for dismissing it. But then he has brought certain facts which we don't think would amount to entering into those facts would not amount to rehearing of the case. So therefore, we are issuing notice to you. Let you respond to this question.
Much obliged.
After 3 weeks. After 4 weeks. 4 weeks.
Much obliged.
15 June. Daily list for hearing, item 15 and 16. Oh, sorry. Supplementary list 24.
Paragraph 42 of
Yes,
the law.
we have passed the order, same order.
Same order.
In terms of that.
Deeply order.
Yeah. This is. I think none of these applications would come after 30th.
30th is the last date, my lord.
That's true.
Item 15 and 16.
My lord, these cases, my lord, I seek for a certain accommodation, my lord. I filed the wakalatnama for the respondent number 7 today, mate. The earliest set of counsels, my lord. 7 days or 10 days, my lord.
You appear for whom?
Respondent number 7. I was the petitioner.
Mr. So-and-so counsel, who has only recently filed his wakalatnama on behalf of respondent number 7, seek some time to get ready in the matter and respond appropriate. The learned counsel for the appellant does not have objection to that. Let this matter come up for consideration under the same heading. After 4 weeks.
23rd June. Item 17.
17, the last order would state that the respondent number 1 had withdrawn his wakalatnama, Your Lordship. That would take.
So somebody else has, nobody has appeared. We have given one opportunity that day. We'll see.
Lordship.
All right. Yes, who appears? It's the same matter.
Lordship, 17.
Nobody has appeared.
No, respondent number 1. Okay.
We'll give one more.
No.
One more, giving one more opportunity to respond number 1 to engage another advocate. His choice. The matter is adjourned after 3 weeks.
25/6. Item 18.
Item number 18 can be passed over for the time being.
What is it?
Pass over for the time being.
Passable for the time being may not be possible today.
But senior is selecting put number.
AICT pay scales.
Yes, Lordship.
Now, a prayer for Passover has been made on behalf of the appellant. Considering the board today, such a request cannot be exceeded. Let this matter come up for consideration under the same heading on after 2 weeks.
19 May. Item 19.
Yes, Mr. Mahanta.
My lord. My petition was dismissed. My lord, I was a deputy superintendent of police, my lord,
Yes.
and working in Dhubri. And that point of time, my lord, I was a IO of a particular case, my lord. And that case, my lord, there is an allegation that I am taking, demanding bribe to send that CD to the court. And accordingly, my lord, a case is registered against me. And
No, that ended in.
that is logical confusion. Thereafter, my lord.
Another show cause with respect to another issue, of course, related to the first issue. Failure to report on.
So now, my lord, my only 2 point, my lord, I'll argue before your lord.
Yes.
First that, my lord, the new show cause notice, my lord, what is the allegation, what is the charge made against me? That is already dealt with by the earlier inquiry. In earlier inquiry, it's gone through, and that is logical conclusion has been done, my lord. Now, my lord, the same thing, my lord, again, my lord, the second show cause notice. That was my first point, my lord. And second point is, my lord, there is no misconduct, my lord.
No, that is not a ground on which we will be hearing. I think these are two distinct. Anyway, who appears for the respondent?
Government, my lord.
My lord. So far, so cause is concerned, my lord, they're totally different, my lord. The earlier proceeding pursuant to the earlier so cause notice that has been on to there. Yes, my lord, different charge has been framed.
Have you heard his argument? You came running, you don't know what he has argued.
My lord, I'm sorry, my lord. I was in another court.
He says it's essentially a rehash of the same misconduct. It's part of the same corpus of allegation. It's a rehash of the same thing. That's what he says. And therefore, here they Yeah. Of 1970s. That applies. That's his argument. Of course, we are slightly reluctant to accept that proposition.
The show cause notice first
Take
show cause,
instructions and then get back to us.
first show cause notice, your lordship, on my lord, page 44.
Forget about the wordings of the show cause notice. It's part of the same gravamen of the charge. That is with respect to the same thing. Now, every time new facts would come and you will start another proceeding. That is his argument. You need a very strong arguments. Get ready in the manner, the way we want you to address us. Prima facie, we are with you, but let's see. We must get very strong reasons to dismiss this appeal.
I'll try to certify.
My lord, I have another second point also, my lord, that misconduct.
Come up for consideration on the same heading or date after.
11-6.
Oblige.
Item 20.
Yes.
Mr. Mishra is
My lord,
online.
please, your lordship.
Yes.
My lord, your lordship heard this matter on 5th of February this year. After
Okay.
that, it was fixed on 10/3, and then it was adjourned for today. If your lordship recall, of course, it's more than 2 months. I had begun the argument. If your lordship permit me, I'll restart because 2
I
months
think
have gone by.
we would be benefited if you restart.
My lord?
We would be benefited if you started.
Oh, my pleasure, my lord, my pleasure. My pleasure. My lord, by this application, the petitioners, my lord, have challenged the constitutional validity of Nagaland Land Resource Development Service Rule 2008. Now, this rule, though the department was, my lord, created on 14/9/1993, for the first time, this rule came into force in 2008. This rule artificially created two wings, technical wing and extension wing. If your lordship permit me, I'll place the rules first.
Yes.
The rule I had given, my lord, last occasion separately.
Yes.
My lord, I'll place short title and commencement. These rules may be called Nagaland Land Resource Development Department Service Rules 2008, and these rules shall come into force on the date of its publication in the official gazette. It has already come into effect. Now, the relevant rule that I'll place before your lordship is Rule 4. Rule 4, classification and scale of pay. The second page.
Yes.
The classification of the services, the scale of pay attached thereto, whether permanent or temporary, as on 1/1/2008, is included in the service shall be specified in Schedule A. If my lord will kindly turn to page 9, I'll take your lordship through Schedule A.
Schedule 1 perhaps. Anyway, it makes the same thing. Yes.
My lord, your lordship will come to serial number 10. Go from the bottom.
Yes.
Assistant Inspector Extension. This is class 3 non-gazetted in the scale of pay of 3,200 to 4,900. Then 9 at serial number 9 is Assistant Inspector Technical, class 3 non-gazetted, same scale of pay. Then my lord will come to 6. Assistant Project Officer Extension, class 2 gazetted. The pay scale is 6,000 to 9,750. Assistant Project Officer Technical is also class 2 gazetted in the same scale of pay. Thereafter, the next promotion is district project officer. And in district project officer, both the wings, they meet.
Yes.
Now, my lord, I'll place rule 6 at the same page, my lord, page 2, second page of the rules. 6, I'm placing mode of recruitment, qualifications, etc. The mode of recruitment, qualification, and other matters connected therewith shall be specified in Schedule 2. Page 10, your lordship will get Schedule 2. Before that, my lord, if your lordship permit me, then I don't have to come back. Rule 8 also I'll place.
All right.
Rule 8.
Eligibility.
Page 3, my lord.
Yes.
Eligibility of candidate. Any candidate having the minimum qualification prescribed in Schedule 2 of these rules shall be eligible for the post given in Schedule 1. Now, your lordship, kindly come to page 9, where the 10, my lord, where Schedule 2 will starts. Now, my lord, I'll start from the bottom, my lord, that is at page 12, serial number 8B. Serial number 8B.
Yes, yes. Where are
Your lordship, serial number 8, small b is the last post. Your lordship got it. Now, this is assistant inspector extension. Then, if your lordship will see the qualification, educational qualification, it is MA Sociology, MSc Anthropology, MSc Geology, MA Social Work, MSc Environment and Ecology, MSc Botany, MA or MSc Geography. Then your lordship will go just above that. Your lordship will see 8A, Assistant Inspector Technical. Here the qualification is BSc AG, BSc Horticulture, BSc Forestry, and BE Agriculture. Then your lordship will come to page 11. 11.
Yes.
This is, my lord, Assistant Project Officer Technical. The qualification is BSc AG, etc. But the qualification which your lordship has seen at 8B, your lordship will find it is not mentioned here. Although on the extreme right-hand column, I'll place this before lordship. 60% of the voter vacant post, I'm reading at 11. 60% of the vacant post of APO will be filled up by promotion from among the members of Nagaland Land Resource Development Service Rules Class 3, Assistant Inspector Technical, who has the same qualification as that of Schedule 2 wide Rule 6 at serial number 1 to 4, or integrated extension training of 2 years, and has rendered not than 3 years of continuous service in that same grade. The basis of selection shall be as prescribed in Rule 11C1 and 11.2 of the rules. 40% of the vacant post will be filled up by promotion from among the assistant inspector. So I get there. My next promotion is to the assistant project officer because of the quota of 40%. Otherwise, if your lordship will see the qualification, I'm not eligible. Then your lordship will go to 4, serial number 4, district project officer. Here also, my lord, because of the quota of 60-40 on the right-hand side, you'll find, your lordship will find, I get promotion up to the district project officer. Thereafter, there is no promotion for me. Whereas the assistant inspector technical can go up to the post of director. Therefore, we have challenged, my lord, these rules on the ground, basically on 2 grounds, my lord.
Yes.
And just one thing I'll point out to your lordship here. Before this present proceeding, we had challenged this very rule by filing WPC 40 of 2020. And Then, my lord, the respondent number 4, who is director, he took initiative for out-of-court settlement to amend the rules, because these rules will not, by these rules are not eligible, my lord, to be promoted above DPO, District Project Officer. Now, after there was an agreement which your lordship has asked me not to refer, I'm not referring.
Oh, that
Your lordship remembers now.
tripartite agreement which cannot be enforced, which
Yes,
means
yes.
nothing.
And then I'm not
You will
placing.
not take judicial notice of it.
Yes, no, I'm not placing, you know. The first day itself, your lordship will see.
Now we remember the facts.
So now, my lord, in that case, my lord, after the agreement, we withdrew the case. A technical wing also had filed a case. They also withdrew with a liberty to come afresh if occasion arises. Now, immediately, my lord, after we withdrew our writ petition, they started giving promotion to the technical branch, technical wing, to the post of deputy director. We objected and we said that you go for amendment and do it together. Then, my lord, as usual, they did not listen. So we filed WPC 60 of 2022. We filed for restraining the government from giving further promotion from technical wing as per the agreement. Now the state filed an AO and they disowned their affidavit, the agreement they disowned. That's why that I have already placed. Now, therefore, leaving with no option but to file this present. Now, if you lordship permit, I'll go to the ground on which I'm challenging.
Yes.
But basically, there are 3 grounds. The first is that the classification of the assistant inspector between technical wing and extension wing is, my lord, arbitrary, and because both the wings are not, because the post held by both the wings are not separate and distinct. Number 2, second ground will be classifications are unreasonable classification with no nexus with the object sought to be achieved. And the third is denial of promotion to the petitioner, consequent denial of the promotion to the petitioners of extension wing is manifestly arbitrary and violative of Article 14 and 16 of the Constitution. These are the 3 grounds on which my case rests. My lord, the first ground that I'll place before your lordship is that the post of inspector held by an assistant project officer held by both the wings are not separate and distinct. And I'm saying this because, my lord, there is a report of the cadre review committee that your lordship, if your lordship can take the compilation, my lord.
Yes.
The compilation, the relevant is, my lord, report of the cadre review committee is at 103. It is dated 16/12. The date is written by, my lord, somebody who received it, deputy secretary of the left-hand column. Now, the relevant that I will place is, your lordship will find at page 106. 106. The committee observed that the nature of works, duties, and functions amongst the APO and inspector of both technical and extension wing are same. There is no distinction in their assignment, and thus recommends to have a relook to maintain a single entry point in the service by clubbing all the requisite qualification into one in phase-wise approach. This was the report of the cadre review committee. And your lordship will see who are there. This I'm showing because I will show the affidavit in opposition filed by the same person, one of them. My lord, on the left-hand column, your lordship side, your lordship will see VK Kenya IAS. Your lordship got
Yes, yes.
at page 106.
Yes, we are at it. We are at it, Mr. Mishra.
My lord.
We have
So
seen all relevant senior officers handling
yes,
the department.
yes. But your lordship will kindly remember so that I don't have to come to this page. VK Kenya IAS. So he is the person who has sworn affidavit, which is, my lord, contrary to what steps that he and the government has taken. I had shown last time up to this place. Now, my lord, the cadre review committee was constituted by notification dated 24/3/2021 that your lordship will get at page 63 of my compilation.
Yes.
I'll place it, my lord. This is 24th of March 2021. The Governor of Nagaland is pleased to constitute cadre review committee for Land Resource Department with the following members to examine the proposal and submit report of the decision, report for decision of the cabinet. Now, what was, my lord, under consideration was upgradation of posts so that we are also accommodated in the higher echelon, my lord, of the cadre. Now, this is, your lordship will see, VK Kenya. He is the person who has circulated the minutes. VK Kenya, he is.
Yes.
Now, my lord, last occasion I placed a transfer orders rather, of both the inspector as well as assistant project officer to show that these posts are interchangeable. And that your lordship will kindly go to page 118 of the compilation.
Yes.
My lord, the first name your lordship will see on the left-hand column is Orrington Odio. He is assistant inspector. It is not written whether he is from technical or extension, but I will show from which wing he is.
Just tell us, he is extension or
It's
technical?
technical.
Technical.
1, 2 technical, 3, 4 extension.
Absolutely. Now, my lord will see these two. Odio was posted in Paren. Now he is transferred to Dimapur in my place. Ao Younger, he is number 3. And Ao Younger, he was in Dimapur. He is transferred to Lunglei, which was, the post was held by the technical. Second person, Rongsung Kaba, he is also technical. So I have been posted to Longleng and he is posted to Paren. They are interchangeable. Then, my lord, another transfer order is of assistant project officer. My lord will get at page 114. 114. My lord, there is a seniority list of both extension and technical. I can show from there that first two are from technical. The notification is dated 17 December 2018. My lord, at serial number 2, he is DPO, District Project Officer, Longleng. He is petitioner number 2, my lord, before your lordship in this petition.
Yes.
And DPO, he is transferred and posted as DPO Dimapur. While Hekato, DPO is transferred to Directorate Land Resource Department in place of the first person. And Kughalu Chisi, he is from technical. It can be seen at page 113. He's from technical. He has come, my lord, in my place in Long Lake. Now, therefore, the assistant inspector and APO, these posts are interchangeable, and anyone from extension or technical can be posted to that.
Yes.
Now, my lord, your lordship, kindly, I'll take your lordships again to Schedule A of the rules, Schedule 1 of 2008 rules. At page 9. My lord will just see serial number 9 and 10, assistant inspector, technical and extension. Same scale of pay, my lord.
That you have shown.
Right. Now, assistant project officer, technical and extension also same pay scale. So what I have shown, my lord, is that these posts are interchangeable and not distinct or separate. They carry same scale of pay and they are interchangeable. There is nothing, my lord, which from where it can be shown that these two posts are separate and distinct because they discharge the same function. As, my lord, the Cadre Review Committee report reveals at page 106.
Yes.
Now, my lord, one decision which I would like to place before your lordship is at page 45 of my compilation. 45. This is SM Pandit and others versus State of Gujarat and others. I've given compilation to all the learned counsels, my lord, appearing for the respondents. Yes. My lord, this is a small judgment. If your lordship permit me, I'll place it. First one. These are appeals by certificate. They raise one common question of law for consideration. The question is whether second proviso to the rule relating to the appointment of the post of deputy collectors in Bombay Civil Service classification and recruitment rules, as well as clause 3 of the rules framed under 309 of the Constitution by the Governor of Gujarat, relating to appointment of deputy collector are violative of Article 14 and 16 of the Constitution. The High Court of Gujarat had come to the conclusion that those provisions are violative of Article 14 and 16. Aggrieved by that decision, the appellants have brought this appeal. Till 1950, the post of deputy collectors were filled by Bombay government, partly by direct recruitment and partly by promotion from the cadre of Mamlatdar. On 6th of February 1950, the government decided to fill those posts only by promotion from the cadre of Mamlatdar. As the result, at the same time, it decided to introduce a system of direct recruitment to the post of Mamlatdar, who in the first instance were to be on probation for 2 years and if found suitable would be confirmed. It was further decided that 50% of the post of deputy collectors will be reserved for promotion of direct recruits in the cadre of Mamlatdar and the other 50% for promotees Mamlatdar. In 1959, Bombay government introduced a change in the mode of recruitment to the post of deputy director. In pursuance of the resolution of the government of Bombay, the Bombay Civil Service classification and control rules were changed and amendments read as follows. I'll place this also, my lord. Appointment to the post of deputy collector shall be made either by nomination. Nomination, my lord, I had seen is direct recruitment. Nomination or by promotion of suitable Mamlatdar, provided that the ratio of appointment by nomination and by promotion shall, as far as be possible, 50% each, 50:50. Provided further that half of the vacancy reserved for appointment by promotion shall be filled directly by directly recruited Mamlatdar who have at least 7 years in the post, including period spent on probation. Appointment by nomination shall be made as a result of competitive examination in accordance with the rules hereto and appended as Annexure 1 from the candidate who are not less than so and so, possess bachelor degree of art, science, agriculture, etc., etc. Now I come to third, para 3.
Yes.
As a result of second proviso in Rule 2 referred to above, out of 50% of the promotees posts from Mamlatdar to those of Deputy Director, 25% were reserved for directly recruited Mamlatdar. In 1966, after formation of the state of Gujarat, the government of Gujarat slightly altered the recruitment rules relating to the post of deputy collectors. The relevant rules may now be quoted. Recruitment shall be made on temporary basis which are existing since 2 years and which are likely to be continued for 1 year and more, excepting those posts which have been created for special work in the revenue department and permanent posts in the cadre of deputy collectors. Appointment on this post shall be made either in either of the following ways: by promotion of Mamlatdar of Gujarat Civil Service class on proved merit and efficiency; B, by direct selection of the result of the competitive examination in accordance with the rule made by the government. The ratio of appointment in available vacancy by direct selection and promotion would be 50-50. But half of these vacancies are reserved for appointment by promotion shall be filled by directly recruited Mamlatdar who have put in 7 years of 7 years service, including the period spent on probation. Rule 3 of these rules is similar to the second proviso of Rule 1. In the Bombay Civil Service classification.
Yes.
Rule 3 of these rules, I'm reading 4. These rules is similar to the second proviso to Rule 1 in Bombay Civil Service Classification and Control Rules framed in 1959. The question, as mentioned earlier, is whether second proviso to Rule 1 of the Bombay Civil Service Classification Recruitment Rules and Rule 3 of the rules framed by Gujarat governments are violative of Article 14 and 16 of the Constitution. The High Court accepted the contention of the writ petitioners, came to the conclusion that impugned rules violative of Article 14 and 16. It opined that both directly recruited Mamlatdar as well as promotee Mamlatdar formed one class. That being so, it was not competent for the government to discriminate between directly recruited Mamlatdar and promotees Mamlatdar in the matter of further promotion. In arriving this conclusion, the High Court relied on the decision of this court in so and so, so and so. 6. The learned counsel for the appellant did not contest the proposition that if both the directly recruited Mamlatdar as well as promotee Mamlatdar formed one class, then impugned rules will be violative of Article 14 and 16 of the 16 on the basis of decision of this court referred earlier. But he challenged the conclusion of the High Court that they formed one class or one cadre. According to him, directly recruited Mamlatdar and promotees Mamlatdar formed two different classes. This was submission of the government. The High Court rejected that contention and in our opinion rightly. Both directly recruited Mamlatdar as well as promotee Mamlatdar are designated as Mamlatdar. They have same scale of pay. They discharge the same function. The posts held by them are interchangeable. There is nothing to show that the two groups are kept apart. The only circumstances urged in support of the contention that they form two different classes is that before promotion to the post of deputy collector, directly recruited Mamlatdar have to put in certain minimum period of service. The condition does not indicate that the two groups were kept apart. The High Court seemed to think that condition is not valid condition. We express no opinion on that question. Court, if it it is valid condition, the same doesn't show directly recruited Mamlatdar from a different class. There is no material to show that the government has prepared two separate seniority lists, one for the directly recruited Mamlatdar and the other for the promotees Mamlatdar. Then these things, and then the appeal was dismissed. So, my lord, the grounds are this, that they are same scale of pay, they discharge the same function, and then the posts are interchangeable.
Mr. Mishra, this is the judgment that you have quoted before
Yes.
us, Pandit. This
Yes.
is 1972.
Yes.
The law has undergone a wide change. You would agree.
My lord.
The determinative factor is something else, and not the salary, not the pay, not the work profile.
My lord.
I think we would be required to go through the decisions of the yesteryears. I mean, of recent origin, where they specify that this cannot be the determinative factor of saying that there are no two groups. See, one, they have gone to the extent of saying that the source of recruitment itself makes them of a different class. Number one. Number two, it cannot be said as a definite proposition that if the work mandate is same at some level, I think they don't form different classes. Now, till that, of course, you're entitled to make this argument on 1972 judgment, but the law has developed in a different way today. So far as
I'll see those law and place it, but it will not be today.
But this proposition is not absolute. Sorry, I didn't have the reason to. I didn't look at this judgment, but then this is not the proposition which is in currency today. Absolutely not. In fact, they have gone to the extent of clearly stating. I mean, other merits of your argument being same. This cannot be a ground today. I think you'll have to look up for another judgment so far as this is concerned. I don't think, Mr. Mishra, the law has changed. Who appears for the other side? Mr. Palgopal. You have the judgment of the recent origin. I think I remember very vividly that they have said so in clear terms that merely the similarity of work or same pay would not make them fall in one class. I mean, that's what I remember of the judgments that I have read.
That's very right, my lord.
My lord, Trilokinath judgment is their constitutional bench.
Trilokinath Mishra.
Trilokinath Mishra.
Chandan Banerjee.
Different lines.
Trilokinath Mishra is not the judge.
No, Chandan Banerjee, it covers everything.
Lord,
please hand it over.
We will, Mr. Mishra, you can continue with your argument. I thought I was trying to keep quiet, but then I couldn't resist the temptation of saying that this is something which has undergone a change.
The issue actually, my lord, is on educational qualification. Educational qualification can be a ground.
Educational qualification also at times, because in nursing cases, I mean, the Supreme Court decided in the nursing matter that this only also would not be the determinative factor.
That's right.
It all depends, because this is in the domain of the rule-making body and create class.
And further, I'll be able to establish, like how my learned friend is debating a little bit, the issues on the constitutional validity of these rules, nothing else. So the direction given by this court, my lord,
No, we don't, Mr. Palgopal, we don't want to take Mr. Mishra by ambush. We don't want to, we would really, in deference of his experience and age and all that, that holds true for Mr. Palgopal also. You'll have to revisit this judgment and the later judgments. And if this is the anchorage point of your argument, I think it doesn't appeal to us today.
My lord.
You have to change the track.
But you will take it up next week then.
We will. But this judgment is absolutely, I mean, this has gone obsolete by the new gloss put over this class.
My lord, we saw where it is followed. We did not get anything, but the judgment is still alive. It hasn't been overruled.
Correct. It has not been overruled specifically. We agree to your, I mean, we have to agree to your submission. You must have made your research. But this law has undergone complete change.
That I did not, that I missed, that I will look into.
उसको देखिए, this cannot be the anchorage point. It cannot be the starting point of your act.
May if I may be permitted not to ambush, just to assist your lordships.
Yes.
The issue is completely different.
Yes.
The 2008 rules was framed in 2008. These petitioners were a beneficiary of these rules up to 2019 because they could come up to the post of district project officer. From there, the turn took place that only those who are actually qualified for the higher posts which they have to take, only they can go. So after having taken advantage of this for 12 years and having not challenged these provisions which are there in existence.
That is again a ground which doesn't impress us at this moment.
Yeah.
What makes us
that's all right. That's all right.
curious, why did you agree for that kind of a settlement?
That is the point. We never agreed for a settlement because the whole game, my lord last time asked me, how did you agree? A deputy director, unauthorized, not competent to enter into this agreement, has signed it without consultation with the government. And the persons who are designated.
We saw that on the last occasion. You're right.
Nothing has happened, my lord. They have taken the ball up.
Mr. Mishra, you find out the other. This is not the.
Yes,
That
I'll
cannot
find
be
out.
a ground. Mr. Chaudhary, you're also appearing in this.
Responding to 2 and 4. I will not be issued very soon.
No, it is.
Lord, my language was on quite a few occasions. My language Mr. Sushara, which things, and then the way to where are we in this matter? Not the matter is. And there are all these promotion. Separate, I mean, where qualification can be respect in respect to the same set of questions. There are two judgments. Looking at Mishra, that's a constitution bench judgment. Then there is 2021 judgment of 3 honorable judges. Where it can clearly say, for the purpose of promoting a classification can be made. It is the same.
Even if it were the same at one.
Yes.
And
Can I give no citation?
Yes.
Please, that clinches the issue.
And in this matter, my lord, for respondents 1 to 4, I have been asked to appear on behalf of the government pursuant to a direction given by this honorable court, the Advocate General.
Yes.
So that's why I'm appearing on behalf of 1 to 4.
It was a request that in such matters.
He
the
may have
Advocate
appeared
General should
earlier, but right now 1 to 4, I'm appearing for.
My lord, I'm appearing for respondent number 6.
Yeah.
All right.
Will you kindly take this compilation?
My lord, I have, my lord, as far as respondent number 6, we have given the written submission also, my lord.
We have it before us.
Yes.
We have it
And
before.
the education
I will
aspect.
see, my lord, get back. Because I have other points also.
12 of the compilation, madam. Page 12 of the compilation. Para 90 guna.
Which case?
This is 1974 1 SSC page 90.
Oh, Tirokinath, that degree holder and diploma holder.
Yes.
Trilokinath, yes.
Mr. Mishra.
I am also relying on that.
Mr. Mishra, can you just come back again? I mean, we don't want to give a longer time. If it is possible for you, only on 4th of May.
My lord.
Just check up. This is a ground on which you are on a weak footing.
My lord, there are other points. As learned Advocate General has said that we have not agreed. I'll show what were the steps that were taken. In any case,
that is a peculiar set of facts in this case. I have never seen. This will never be witnessed by under any circumstance, under any government. With respect to rules, how can there be a settlement?
You can't do settlement of rules.
Before the court. Can there be a mediation or something? Or
In fact, the procedure is prescribed as to how to make the rules. They have taken the ball up to the goalpost. They could not score because they realized that consent of the chief minister in terms of 24 of the rules of executive business and also, please wait, and also the chief secretary's permission. All this is required. They don't get anything. The deputy director, the joint director He says the government is bound by me. He is not the government. And pursuant to that,
We are not
You
going to
need
that.
go into that.
well,
We have stopped it, foreclosed it at the initial stage.
and the Banerjee judgment, which I mentioned to your Lordship, Justice Chandrachud's judgment, that takes care of all these judgments, Trilokanath and all the other judgments. Where
Can you
they
tell
have
me the
given
reference?
7 points,
Reference?
7 points they have given.
Give me
Please,
the reference.
Mr. Mishra, you have any local council here who can take the
And
references?
my junior is there, my lord. Mr.
Yes.
Vikas Prasad is there.
One SCC page 19.
Mr. Chaudhary, why don't you give him a copy of this?
He's ready, but nobody is there to get.
No, no, give.
Asa,
Ah,
Is there?
okay.
yes.
He only takes from me all whatever I rely on and he doesn't give his own.
No, Mr. Chaudhary, please don't accept this allegation. Please give it to him.
Yes, ma'am. Continue.
That was on the lighter vein, my lord.
Come to page 44 of the compilation. Page 44. Para 27 of the top pillar. Principles which emerge from the above line of precedents can be summarized as follows. Please come to Roman 3. Generally speaking, educational qualification is a valid ground for classification of persons of the same class in matters of promotion and is not validly provided. But this is the answer.
I have given the judgment for your.
You did it
It also says, and you have not read the most important part.
Yes.
The clincher is 5,
Yes.
Roman 5.
Yes, yes.
That is the clincher which
Educational qualification may be used for, yes, introducing quota for promotion for certain class of persons, or may even be used to restrict promotion entirely to one class, to the exclusion.
to the exclusion of the others. This is absolutely clear. Otherwise, you see what, Mr. Mishra, you see what happens in Coal India.
Well, may I have the reference, my lord?
Yes.
Please give,
21 SCC on.
Mr. Chaudhary,
773.
Mr. Chaudhary, please give the compilation.
Okay.
Give the entire compilation.
Okay. 2021 SCC online SC 773 para 27. This is my subject.
That is before your Lordship already.
That is the judgment which you have also given.
Yes. Chandan Banerjee. Justice Chandan.
Yes, Chandan Banerjee versus Krishna Prasad Ghosh. Yes.
There is no exclusion in.
I think,
unlike
I think we need not go to any other decision except this.
this is clear. And also the nature of the job which they are performing. It's not that he was transferred from here to there. I will explain to your Lordship.
So, Mr. Mishra, do we say arguments? We will keep it open for you, but do we say that we post it for judgment?
So, my lord, these judgments I refer, then I have not completed. Whatever I have in my pleaded case, I will please refer. Lord.
So, what time would suit you? On
My lord, 5th is a hearing day. If your lordship can take it up.
All right, 5th of
Me.
I have difficulty.
Please, you have a difficulty there.
In May.
You appear online.
I came
now that
specifically for this.
now
Even last time.
Mr. Chaudhary, once he has pointed out that it has been argued thrice or 4 times,
7, 8 times.
then we would not like to make it. Can you appear online, Mr. Balgopal? If you want, we can keep it at any time which is convenient for you. Because we have asked you to appear in this matter personally. 5th, you have difficulty.
The entire May is from here to there because the last month.
Spare half an hour.
Keep it on 4th.
Spare half an hour.
Keep it on 4th. 4th.
Before the result will come, Mr. Balagopal. Your state.
He's a state, did not go for elections.
He's talking of my parent state. Is it? He's talking of my parent state, Kerala. The election result.
You met me there.
Yeah.
No, but lawyers are more interested in bar council counting.
Yeah.
I don't know how Mr. Chaudhary is here.
My lord, can keep it.
Huh?
It's going on.
How long does it take? Last month I visited my home state. There also they said they are busy counting.
Today the second is being counted. Then once it is over, the elimination round is done. It's long. It's a very
Complicated process. Much more than US president.
Oh, yes, yes.
On fifth, Mr.
Fourth you can take.
Huh?
Fourth.
Fourth, Mr. Mishra, any difficulty? After three.
No, let it be fifth. No.
Acha, fifth. On fifth. On fifth.
If your lordship will take it up at 3, my lord, I may not be able to finish. There are other points which I must place before your lordship.
We'll keep it at 2.
Yes, on 4th.
On 4th. On 5th.
On 5th, yes. Yes, my lord. 5th I suggested.
4, you never know.
My lord.
I mean, what would be the emotional level of some of the people? So let it remain on 5th at 2 o'clock.
My lord.
Okay.
Obliged.
Arguments to continue.
And let us have time for him and me so that we don't extend, because we have already argued the third time. 30 minutes should be over.
All right. Mr. Mishra, there is a request from your colleagues that you have to restrict your argument within 30 minutes. I would not have said so for the reason of your seniority in age. I would not have restricted it, but now with the request of the others, we say that you restrict it to 30 minutes.
He's the youngest man.
It will be difficult, but anything that I'm arguing, if your lordship stops me, I'll stop.
No,
Please don't bind me.
That normally we don't do, especially when you don't appear physically, you appear virtually. We don't do that for the deference of any person who is of your age and ilk. We don't do that, but you please, you are capable of doing it.
I'll try my best. I'll try my best. Not a minute more I'll take, my lord. I
take an assurance from you that you will not take it otherwise if we stop you at some point where we have read.
No, that's what I'm saying. Your lordship, that is your lordship's prerogative. After all, we are assisting your lordship.
All right. You see, for the reason of my comment, I mean, everybody here comes from the same stock, but then we have seen how sensitive senior advocates become. If you restrict them, they get very, very wild. And I've had the occasion of assisting senior advocates, and I have also had the occasion to hear those senior advocates. Non-Nigerians who would feel stifled if asked by the bench to stop. But one day or the other, it has to be within the time limits. But then I'm rather careful with senior advocates.
Your lordship has seen the Chief Justice CJI, my lord, said that we will restrict the senior advocate. They should say how much time they will take. Last 9 days, that Sabramati or something temple case is going on. Sabrimala, 9 judges bench. The argument is not getting over.
Now, there the issues are such. So many things about religion, Article 25, 26, and so many arguments are being made.
Here, my lord, your lordship may. Today also your lordship stopped me.
All right, so we'll finish it on 5th.
Yes.
5th.
2 o'clock.
Arguments to continue. Re-notify on 5th of May at 2 p.m.
Yes.
And all of you, please be here on that.
Obliged.
Item 22.
When is that matter, Mr. Balgopal of Nagaland, that inner land permit?
14th. Your lordship wants to keep it 14th.
No, let it remain.
14th.
May I please, your lordships? Your lordship, I am appearing on behalf of the petitioner in this case, my lord. In this case, my lord, by way of this petition, my lord, the impugned order judgment passed by the learned DR80 Kolkata in appeal number 23 of 2019, confirming the impugned judgment order dated 14/2/2019 of learned DRT Gauhati bench has been challenged.
Who appears for the respondents?
My lord, the council was appearing for PNB, my lord. And they have counsel for the Punjab National Bank.
Who appears for us? Mr. Ganguly.
Yes, ma'am.
Or Mr. Dhanu.
And they have already filed the reply also, my lord.
Where are they? They are not here. Legal counsel for the petitioner is present. There is no appearance on behalf of the respondent bank. Giving one more opportunity to the respondent bank to contest this case. The matter is that you have to inform him. We are adjourning it to up to weeks. We are keeping it after 2 weeks. Everything is over. There is no urgency to hear it tomorrow.
My lord.
We'll do it after 2 weeks or 3 weeks, whichever is.
As you lordship.
3 weeks.
Yes. Thank you.
25 5. Please forward.